Well, I am in default. I have not been able to draft it. Lordship, kindly grant me.
Considering the urgency of the matter, your lordship was pleased to grant them 10 days.
Yes, my lord.
I put them on notice.
That's it.
After 20 days, they are coming and mentioning that there is some urgency now.
Lord, it's a voluminous.
What is the matter?
Well, the matter is returnable on the 5th.
Their instance, our bank account has been closed.
Okay. Matter is returnable on the 5th, my lord. Lordship grants me at least 10 days time more.
10 days, 20 days already over.
20 days.
I've tried, my lord. It's my difficulty. I'll just indicate, my lord, it's ready, but at the same time, the person who's
The
supposed to.
non-commercial. When the date is
Non-commercial.
fixed?
It's 5th.
Returnable on
5th of
March.
March. Okay, come on 5th of March. In the
Very
meantime, we will see.
Very
this.
well. Grateful.
Come on 5th March.
May I have your lordship's leave to mention a matter for extension of interim order when the matter is not there in the list? Lordship had heard it last Friday. My lord, I forgot to pray for extension. The interim order is expiring tomorrow, 4th of March. May it be listed as to be mentioned so that, my lord, if your lordship
Give-
can
give-
consider the prayer. I am mentioning
Extension
upon
of
notice.
interim order.
Grateful.
May I be permitted to mention one matter, appellate side matter, my lord? For non-prosecution, my lord, this matter,
Appellate side.
appellate side matter, my lord. This matter is fixed on, my lord, 3rd April at 4 p.m. My lord, demolition matter, my lord, demolition almost complete. My lord, the petitioner does not want to proceed with this matter because further demolition may damage the property. That's why she is also co-sharer of the property. Now she is interested to proceed with the writ petition. My lord, let it appear, my lord, any day on.
When the date is fixed?
My lord, 3rd April at 4 p.m.
For compliance report by the municipal authority. That is the contempt. That
Yes, not contempt, my lord. The compliance report. Municipality prayed for 2 months time.
Correct,
And
correct.
demolition is almost complete.
Correct.
Almost complete. That writ
You are
petition-
referring to whom?
petitioner. My lord, petitioner at this stage, my lord, the petitioner does not want to proceed with the matter. So-
Then I will deal with the petitioner.
Yes, my lord.
If the petitioner wanted to continue with the illegal construction, then the court will deal. Court will so moto take the matter. No problem. I know what is going on. The court has passed an order. You file a writ application. Court has passed an order for demolition of the illegal construction.
My lord.
The authorities are not making the complying the order. Then you made the prayer before this court. This court has issued the notice. The authorities are going to be comply with the order. Now you are coming with this. Let us, if I will record all the things, let us come on 5th of April. Compliance with the compliance report. We'll see how the petition will withdraw the matter. The court will take so moto. You are playing with the court. You wanted to continue with the illegal construction?
No.
Then? Yes.
Your Lordship, I am mentioning our open notice, Your Lordship. CS
What is the
Com number
matter?
701 of 2024, Your Lordship. That matter, the Tiswa kitchen involved, wherein Lordship by order dated 24th of February decided the occupational charge, directed us to pay the occupational charge. Your Lordship, the only difficulty is in that order, there is a reflection that GA4 of 2024 is disposed of. No, Your Lordship, the GA4 was not completely heard. We are in a perception. So I'm praying for a necessary clarification of this order.
GA4 filed by whom?
GA4 filed by the plaintiff. I am for the defendant.
Huh?
I am for the defendant. GA4 was filed by the plaintiff.
Correct.
Against occupational charge,
Correct.
we filed our objection.
Hmm.
Prior to the objection and GA4, we filed two applications, GA2 and GA3. That is still pending. The Section 10 application and Order 39 3A application.
Correct.
Now, Your Lordship, Your Lordship has directed us to pay the occupational charge this much of amount and with arrears.
Correct.
But Your Lordship, the difficulty is GA4 has been decided without any observation about my written objection which we have filed, because
The advocate who argued the matter, bring that advocate before this court. You are not argued the matter, so
my senior, he will
let he come.
kindly take the matter
He has
to
given
be
the
mentioned.
consent. He has given the consent in his presence. Initially, the court was of the view 75,000.
Yes,
Subsequently,
Your
he has come
Lordship,
with the plea and the court has picked the
Your
50,000.
Lordship, we are not on the occupational
With
charge, Your
regard-
Lordship.
Then, with regard to
The
the
only difficulty, Your Lordship, in our opposition, we took a specific ground that he himself, the plaintiff himself,
have
is
you-
not an honor.
have you read the last line of the order?
Yes, Your Lordship.
Read it. Read loudly.
The plaintiff is directed to provide the details of the bank account to the defendant within a week from date. GA Com 4 2024 is
I do
disposed
that,
of.
75,
The
50,000.
defendant is directed to pay the present occupational charge regularly without fail on or before 7th of every succeeding month from the month of March 2025. It is further made clear that if the defendant fails to pay current monthly occupational charges, the plaintiff shall be at liberty to take appropriate. We are not on that, Your Lordship.
Then?
We are ready to comply with the direction of Your Lordship. My only difficulty is we are in a perception that our GA is still, the
Sir,
GA4
your
is still
arguing
pending.
advocate had the knowledge. I will hear the section 10 application. This is only with regard to the
Your Lordship, then in that even I am requesting for Your Lordship kindly take this
Yes,
matter
another
to
matter.
be mentioned heading,
Call
Your
the next
Lordship.
matter.
My lord, may I permit
Who is the senior?
I'll bring this in.
May I permit to mention, ma'am, this is a PLA matter and I need a
No.
application.
Yes, next.
Yes, the application, my
My lord, may I permit to mention, my lord, this is a testamentary matter running in the monthly as item number 208. This is for issuance of citation. I'm praying for application.
Let us wait for the for 2-3 days. My original list may finish, then I will see to that.
Lordship, may I be permitted to mention item number 75 of my lord's list, my lord. It was supposed to appear on the 5th, my lord. My lord, I am praying, my lord, my affidavit in reply is ready, my lord. Just 1 day time, my lord, it is going to expire tomorrow, my lord.
Let it come tomorrow. Let it come
My
tomorrow.
lord,
If
my
you
lord.
want.
I'm grateful.
But I mentioned the wrong serial number. Wednesday, I mentioned the serial number of the Tuesday matter. Thereafter, my matter appeared as item number 1 and 2 from other matter. I have mentioned this matter before also. My lord asked me to come in the March.
So today is the first day. The monthly list has
But I
first
was-
list. Let come after 2-3 days. Have come after 2-3 days. Come after 2-3 days. I will take the matter. Let some matter be disposed of, then I will take.
My
the
lord,
matter.
similar playing for inclusion in the list, my lord.
Which
PLA
one?
matter, non-contentious matter.
PLS I will take. Come after 2-3 days.
My
I
lord,
will
my
take.
lord.
Let
I have your
My lord.
lordship
Great.
kindly. This is a to mention a commercial suit. Your lordship have been very kind enough to fix it for witness action on next Monday, 2 p.m. But the difficulty is that your lordship, the company's legal team has changed. I was not able to lay my hands upon certain original documents. So I was praying
come
for,
on that day with the cost of rupees 1 lakh. I will adjourn the matter. You know, fixed matter. The court is very.
lordship, that is why one.
See, all the advocates are mentioning this court is not having the time because of the fixing of the matter. And once the matter is fixed, then you are telling that the case is to be adjourned. I will adjourn the matter subject to payment of cost. No problem. I will take the matter. Yeah, you take note, but keep it in mind. You have to pay the cost of that adjournment. Fixed matter.
To be mentioned, your lordship.
Sorry.
May I have your lordship leave to mention a matter? Lordship, it is a non-commercial matter. It is a suit pending. It is a matrimonial suit which is pending before the commercial California court also. Your lordship, if it could be fixed any.
Already a matter was mentioned earlier. When the matter is fixed, no.
Lordship, it is running in the monthly list as item 93.
So when the matter was heard, you one of the other ways you are
Lordship,
taking the adjournment.
on the last occasion when the matter
Third
was
time you are
heard, there
mentioning
was a.
the matter every
Yes,
day.
lordship.
Take the matter.
This is lordship, this is a testamentary matter and which was supposed to be running in the list as per the master summons on 24th. So it is not
What do you want?
for to be transferred to the daily list for the hearing of the GA application. I'm for the objectors.
What's the GA?
GA for condonation of the delay.
Delay of?
Delay of 50 days.
No, for?
Delay in filing the caveat with the
Come
wakalat.
after 2-3 days. Let within 2-3 days this list may be exhausted. I will take the matter.
Lordship.
May I be permitted to mention one non-contested testamentary matter for inclusion, my lord?
Come after 2-3 days, madam. Let this week be, come next Monday. I will mention. I will.
Lordship, may I be permitted to mention in this PLA matter, your Lordship had granted the letters of administration to the petitioner. I am praying for leave for drawing up of order.
Grant.
Grateful, Lordship.
This is an assigned section 34.
Yes, sir.
It has come up at my instance, Miller.
Yes.
Where the section 34 and 36 was released by the then Miller regular bench because Justice Kapoor
Malad
had
can fix it any day in Malad in April. We'll come back.
But
Malad. We have
my problem is, but I'll tell you, Lordship Miller. The section 36 was heard by your lordship, my lord. We did not succeed up to the Supreme Court. It's not too easy to, my lord, pay 2,200 crores. So my lord, the execution
Not easy to pay.
easy.
Malad, that statement, Malad, I shall try and ignore, Malad, that statement.
So my lord, the execution is
If the
proceeding.
award gets
Well,
upheld, Malad, what will happen then?
That's a different thing, but I'll
But
try
that's
to
the
resist
law.
it.
That's the law,
Resist
Malad,
it,
that you have to secure.
Yes, to the
Anyway,
extent
it doesn't matter,
possible.
Malad. Section
But kindly,
34,
my
whenever,
lord,
Malad,
What do you want?
Malad,
my lord, any day, my lord,
Malad,
in
we'll have
this
to
matter.
file affidavits. Malad, we'll file affidavits, Malad, within 3 weeks. Probably.
My lord, there are two ways of looking at it. Kindly do not take me amiss. But either the execution petition also comes before this court so that your lordship can hear both,
We'll ask
or
for
the other way around.
We'll ask for the execution to be here, Malad, if at all, Malad, necessary. Otherwise, Malad, section 34 has to, Malad, proceed,
Because
Malad,
I have a
independently.
section 47 over here. On the ground,
Where? In this court?
no, in the
Execution
execution.
court. Execution court.
On the ground that these kinds of awards cannot be executed because of the bar in the law. Right, wrong, Miller, that will be decided by the court. Now, in the meantime, Miller, I desperately require the section 34 also to be heard. So, Miller, I have no choice of court. Either I would only pray that both the, one court, he has both.
Let this be go to the execution court.
No,
Or
Malad,
the other
let
way,
us-
whichever.
Whichever way, Malad, let us,
Whichever
Malad,
way.
kindly, Malad, let us complete the pleadings, then, Malad, we'll, Malad, see, Malad.
Well, I appear for the Industrial Development Corporation. I am supporting Mr. Dotto. Well, I am also one of the award debtors. Well, only thing is, if your lordship is kindly, please to fix the matter immediately because the execution is proceeding as your lordship has heard. 2,200 crores is not an easy sum of money to pay. So, we are interested.
Or your
No, no,
lordship,
well,
may I say this?
if
Ma'am,
your
kindly
lordship
take
kindly
care.
fixes the matter, there is no need for
This
affidavits.
matter
The
goes to
award
the
will
regular
proceed.
court, regular bench. Now, my lord, the regular bench does not have any difficulty. We can, my lord, try to impress upon her
Malad,
ladyship
this
to, my
is,
lord,
Malad,
take it
Malad,
along with
this is,
that.
Malad, assigned to this court. Malad has already heard section 36.
In
Malad, let us come back, Malad, with our pleadings.
without affidavits, there is no affidavits required to be filed in considering an award. It is only the award. In that case, your lordship will kindly fix it up immediately.
Malad, whatever,
The
Malad,
prejudice will be immense otherwise.
Yes.
So how soon you file the affidavit?
Malad, gives us, Malad, 2 weeks, Malad, we'll file.
Or if you want to take the matter, because it is
No,
assigned.
Malad, we'll
But
let us, Malad, be.
my prayer is one court hears both.
Correct.
Well,
No,
whether,
Malad,
my lord, this
No,
court,
that's
that
why.
court.
That's
This
why.
court,
Because it
Malad,
is
has
assigned
heard-
matter. I cannot release.
Malad-
If you want, you make the prayer before
The other court. Yes, Malad, we'll do
the,
that. We'll do
to
that.
the Chief Justice that it can.
Oh, very,
Yes,
very,
yes.
very,
The Chief Justice can.
Yes, yes,
very,
Malad, we'll do that.
very.
No problem.
Malad, we'll complete our pleadings, Malad, here, Malad, then, Malad, kindly fix it, Malad.
Very good, great.
So and so opening for the petitioner, so and so opening for the respondents. Full stop. The counsel for the respondent prays for time to file affidavit in opposition in connection with AP 28,
Yes.
27,
27.
AP 27 of 2023. Let affidavit in opposition be filed within 2 weeks. Reply, if any, there to be filed within 1 week.
No, 1 week.
1 week. Full stop. Please the matter on.
Well, sometimes it's the first week of April. Ma'am.
Please the matter on 4th April 2025 for hearing.
But could your lordship fix a time, my lord?
Let the pleading complete.
Well,
Yes, yes.
If the pleading completed, then I do.
Malad,
My lord, in the meantime, we'll take
can it
steps.
be,
my lord.
Malad, 7th or 8th, Malad?
7th or 8th. Then 8th.
8th.
Yes.
I'm grateful.
I'm grateful.
Thank you.
And then, Malad, can we, Malad, file the affidavit, Malad, in 3 weeks, Malad? Because, Malad, because I think, Malad, we'll 3 weeks
2
and
weeks.
1 week.
3 weeks, 2 weeks.
1 week.
3 week, 1 week.
Grateful, Malad. Grateful.
Now,
My lord, I appear for the plaintiff.
Hmm.
My lord, kindly sees paragraph page 16 of the plaint.
Page
16. My lord, paragraph 34.
Purpose of jurisdiction, the suit is valued at over.
At over.
It's valued at rupees. Over it is to be
My
deleted.
lord, yes, my lord. I'm sorry, my lord.
So and so bring for the plaintiff. The matter is listed as to be mentioned on the prayer made by the counsel for the plaintiff. Full stop. Counsel for the plaintiff submit that at paragraph 34 of the plaint, 34 line 1 of the plaint, the plaintiff has added the word over Invert over, unless the plaintiff intend to delete the word over from the said paragraph. In view of the submission made by the counsel for the plaintiff is granted leave to delete the word over at paragraph 34 of the plaint at line number 1
And-
in course of the day, and after deleting the same, the advocate on record of the plaintiff put his initial over the same.
I'm grateful, my lord.
Yes.
Your Lordship, in this, on 21st of January, January 2025, Your Lordship was pleased to grant liberty to
Cure the defect.
cure the defects, Your Lordship, and pursue. Earlier to that, I had inadvertently missed to take leave under clause 12. Your Lordship, that leave was also granted. That was.
So now why?
Your Lordship, at page 44, I had shown that the part cause of action, both plaintiff and defendant are outside, but at page 44, as pleaded in para 9, the bank guarantee and part payments were received within jurisdiction, which is at Park Street, Your Lordship.
So what you want now?
Your Lordship, the master had shown that both the parties are outside. So, Your Lordship, the defect, I had also given a letter to the master that the defects, I may be allowed to clear the defects. This, as I was informed by the master's office that the file was shown to Your Lordship, and Your Lordship was pleased to direct the matter to come up as to be mentioned because the defendant and plaintiff both are outside. So, Your Lordship, I had shown page 44, and thereafter Your Lordship was pleased to grant me leave under clause 12, Your Lordship.
Territorial in regard to the address of the plaintiff. Serial number, list of defects.
I went to the office of the master and explained them that page 44 part cause of action has arisen. So Your Lordship was pleased to grant the leave.
Page 44.
Annexure D. Third paragraph.
Both are outside.
Your Lordship, plaintiff and defendant both are outside, but part payments have been made within the jurisdiction. 15 Park Street,
Where you
APJ
mention-
House.
Where you mention in the
Para 9, Your Lordship, we have pleaded
no part cause of action where you mention.
that para 9, page 5, that while advance payment of 11 crores plus amount was paid by the plaintiff in the agreed tranches, the defendant at first did not adhere to its obligation until a service of email copy of the bank and the amount and purpose of the bank guarantee from which the defendant would be receiving the performance bank guarantee, sharing the requisite bank guarantees within 4 banking days of the payment of 50% of the agreed advance payment by the plaintiff.
Correct.
However, belatedly and contrary to the agreed terms as agreed between the parties, the defendant eventually furnished the bank guarantee totaling to rupees 1 crores 67 lakhs, a copy of the acknowledgement and advance payments and bank guarantee annexure D.
Bank guarantee, where the bank guarantee was furnished?
Your Lordship, page 44, Park Street, APJ House.
This one.
Your Lordship.
So what do you want now?
Your Lordship, this has come at the instance of the master because they stated that plaintiff and defendant both are outside. So how could the leave be granted?
So and so offering for the leave was not granted.
Your Lordship,
Leave was not granted.
your leave was granted. I have in the prayer portion,
So
concise
offering for the
statement everywhere I have
the matter is
indicated.
listed has to be mentioned on receipt of the office report. Police report. It is fine that in the officer submitted the report
4 defects were given,
the-
Your Lordship.
the effect that both the plaintiff and the defendants are outside the jurisdiction of this court, but the plaintiff has not mentioned in the cause title with regard to the fact that the plaintiff and the defendants are outside the jurisdiction of the court. Police counsel for the plaintiff submit that though the parties are outside the jurisdiction of the court, but part cause of action arose within the jurisdiction of this court as the defendant has furnished bank guarantee. Who has furnished bank guarantee?
Your Lordship, the defendant had furnished the bank guarantee.
Defendant has furnished the bank guarantee in the which bank?
Kotak Mahindra Bank, 15 Park Street, APJ House, Kolkata,
At the Kotak
7 lakhs.
Mahindra Bank, Park Street branch, which is within the jurisdiction of this court.
And advance payments have also been received by us.
Considering the submission made by the counsel for the plaintiff prays for leave to add to amend the cause title of the plaint by incorporating that plaintiff is residing outside of the jurisdiction of this court and the defendant is residing outside of jurisdiction.
Your Lordship, amend instead of that leave be granted to do it by hand, Your Lordship.
Correct. Police. Considering the submission made by the counsel for the plaintiff is granted leave to make appropriate correction in the cause title of the plaint by incorporating in the address of the plaintiff as well as in the address of the defendant that they are outside the jurisdiction of this court within
1 week, Your Lordship.
within a week from date. Full stop. After carrying out the amendment, the plaintiff is given liberty to re-verify and reaffirm the affidavit of the plaint within a week thereafter. ঠিক আছে?
Wait, please, Your Lordship. This is my suit, madam. On the last occasion, Your Lordship had granted me leave to cure the defects. I am informed by the department that
Since suffering for the plaintiff, the matter is listed as to be mentioned on receipt of the report of the office. Full stop. By an order dated
February
21st of February 2025, this court has granted leave to the plaintiff to cure the defects as pointed out by the department. Full stop. It is fine that the verification and affidavit is also to be reaffirmed and re-verified. Accordingly, the plaintiff is granted leave to re-verify and reaffirm the affidavit of the plaintiff within 1 week.
Lordship, make it 2 weeks, Lordship. I've already lost 1 week.
Within 2 weeks.
2 weeks from date.
Within 2 weeks from date.
Grateful.
Next.
Lordship, in this matter, I'm appearing for the plaintiff, Your Lordship. Lordship, in this matter, an application has been filed, GA3, by the defendant, Lordship, seeking condemnation of, as per the defendant's prayer, seeking condemnation of delay for filing of written statement, which is beyond 120 days, Your Lordship. If Lordship kindly takes up the last... They have filed the Lordship, as per facts, the written statement has not been filed as on date. 120 days has 120 days.
Not according to us.
Lordship, may I please?
Beyond 120 days, it's not possible.
Lordship, I wanted to. Lordship, I am appearing for the plaintiff. Lordship, on the last date, I just wanted to draw your Lordship's attention to the last order. Lordship, on the last date, defendant has made extensive submission, Lordship. Lengthy arguments have been made and it has been concluded also. Lordship, if Lordship kindly takes up Lordship's order, your Lordship, defendant has only sought some time to place on record a judgment where of Honorable Supreme Court, whereby it can be shown that written statement can be accepted even if it is not filed beyond 120 days. If Lordship takes up the page 2 of the last order, your Lordship, defendant has filed an application such and such. Counsel for the defendant has argued at length, but he has prayed for time to bring some authority to place before this court whether time can be extended to file written statement or not after the period of 120 days. Lordship, my humble submission, Lordship, that let this be scope,
to argue at all.
this scope be restricted to this.
Let they argue.
I bow down. Lordship, I just wanted to, Lordship, indicate on the last occasion what happened.
First of all, I thought I should go on that side because I'm the applicant.
No, mic is given to you.
Yes. One thing, I just, I was brought in later. One thing, I don't know whether has seen that. The service seems to be on 16th May. Can you look at their affidavit?
Your affidavit?
Affidavit in opposition, my lord. Their opposition, my lord. The
Manutosh, affidavit in opposition का है?
Well, there are two dates of service. Well, Affidavit in opposition.
Affidavit in opposition in GA3.
Yes, my lord. GA3. And my lord, can you look at page 14?
Have you filed? Affidavit filed? Affidavit in
Has
opposition.
been filed. In fact, I took your lordship through the affidavit on the last occasion as well.
CBC
Last one. Yes, Lord.
Page?
My lord, page 14, my lord.
Yes.
My lord, will see, my lord, the first date is 16 May. Through, my lord, the
Served on 16 May.
district court.
Upon one.
Because, my lord, here, my lord, we are outside jurisdiction. So, whether, my lord, this date will be considered 16 May or, my lord, the other date is through speed post on 30th March. If 30th March, my lord, some arguments will have to be made. If 16 May, my lord, no arguments have to be made. Then, my lord, we are within time. Because, my lord, this was filed on, my lord, 14th, comment date. On, my lord, 26th, 26th July, my lord, 2024. So if it's 16 May, my lord, then there's no difficulty.
When you affirmed?
My lord, affirmed earlier, but filed, my lord, on 26 July 2024.
Which application?
Yes, my lord.
Application filed on 30th July.
30th July.
30th July.
30th July.
30th. Then also, my lord, it's within.
And May. Yes.
Then, my lord, it's within time. Now, my lord, I found, my lord, order, kindly, my lord, come to order 5, rule 9. Written statement, copy is shift. And written statement, my lord, affirmed, though, my lord, that may not be, because, my lord, we have not filed it. It's, my lord, also, my lord, ready. And, my lord, that's affirmed, my lord, on 10th July.
Yes.
My lord, kindly look at order 5, my lord, rule 9 is delivery of summons by court. My lord, the one is where the defendant resides within the jurisdiction court in which the suit is instituted or an agent. My lord, that within the jurisdictions and such. Then, my lord, 4 is, my lord, notwithstanding anything contained in sub-rule 1. Where a defendant resides outside the jurisdiction court in which the suit is instituted and the court directs that the service of summons on that defendant may be made by such mode of service of summons as is referred to in sub-rule 3, except by registered post. Acknowledgement due. The provisions of rule 21 shall
not apply.
Not apply. So, my lord, here, my lord, no direction, my lord, was given. And 3, my lord, will find service of summons may be made by delivering or transmitting a copy thereof by registered post, acknowledgement due, addressed to the defendant or his agent empowered to accept the service, and such, or by any other means of transmission of documents. So, registered post, acknowledgement due.
Order?
My lord, order.
Order 9 rule?
Rule 9, my lord. Order 5, rule 9. Rule 3, sub-rule 3. So, sub-rule 3, sub-rule 4
and my lord looks at sub rule 21 also.
Yes.
A summons may be sent by the court by which it is issued, whether within or without the state, either by one of its officers or by post or by such courier service as may be approved by High Court, by fax message or by electronic mail service or by any other means and is provided by rules made by the High Court or to any court not being the High Court with the place being the defendant resides. So, my lord, in my humble submission, my lord, there are two modes of service. My lord, the speed post with acknowledgement due is not, my lord, something, my lord, which is contemplated, my lord, under the rules. The first mode, my lord, which is done, my lord, will find, my lord, that is, my lord, through the district court. So that, my lord, would be, my lord, in my humble submission, my lord, considered as the proper service.
But this commercial side procedure rules.
My lord, it doesn't have, my lord, just take out the commercial.
अरे वो जो procedures है ना
देखो,
notification.
commercial stuff.
Okay. उस
My lord, subject to correction, my lord, I
Part 5, Chapter 1. Service of process by courier, fax, email, electronic service, short message service.
Chapter. Okay. On the writ of summons, my lord, part 5. My lord, looks like, my lord, it requires, my lord, a direction, my lord, by court, which, my lord, was not done in this case. Uh, 10(2) requires, my lord, the mode of service.
Yes.
My lord, requires, my lord, court, my lord, to fix a mode of service.
Correct.
In this case, my lord, that was not done.
But anyhow, it was sent.
Yes. So, my lord, whether, my lord, now, my lord, service would be, my lord, when, my lord, it was sent through district court or, my lord, through speed post with acknowledgement due, my lord, that's the issue. That's one issue. So, my lord, if, my lord, considers it, my lord, that the proper service is, my lord, through the district court, then, my lord, 16 May.
No, but here the question, you are not questioning with regard to the service. You are not questioning, it is not that it was not delivered.
No.
It is delivered.
Delivered.
If it question of services, then the court has to require to see whether it is a proper service.
Because, my lord, from date of service, my lord, the time will run, my lord, from the date of service. If the writ of summons, my lord, is served properly, then, my lord, date will run from that time. So, 120 days, my lord, is now, my lord, the outer limit. So, my lord, if 16 May, then, my lord, within 120 days, my lord, we have filed the application. Now, 30th March. So, my lord, my first submission is, my lord, kindly consider my lord, 16 May, my lord, as the date of, my lord, effective service.
If you go by the 30th March, so
Then, my lord, then
then
30th March, then, my lord, we are, my lord, in calculating, my lord, in days
it
really.
will be April, May and June.
Yes.
June it 1st July.
Yes.
1st July. Or 30th June.
30th.
30th June. Or 30th June is the
30th July, 120 days. So,
120 days.
120 days.
July. 120 days
28th July.
expire 28th of July.
28th of July.
Correct.
28th of July.
Correct.
And when you affirm your affidavit?
My lord, this affidavit affirmed, my lord, on 11 July.
No, written statement.
Written statement 10 July. That is, my lord, within time.
That is pending before the appellate court, whether the affirmation of the affidavit is to be considered, because I have passed some order.
My lord,
Affirmation will not.
my lord, I don't know, my lord, I saw that, my lord, this is, my lord, that
Raizada marbles hold the field as of now.
No, but there, my lord, the application itself was filed later.
No.
Yes, that's what I said.
Still, I am telling Mr. Banerjee, still I am telling with regard to, and I also on many occasions I inform the bar before this court application is not necessary. See, this is a discretion of the court. This is a discretion of the court. Correct. And as per the judgment, as per the order 8 rule 1, it is a mandatory, as per the judgment passed by the Supreme Court, it is a mandatory after 120 days, the court cannot.
Correct.
Within, after 30 days and within 120 days, this is a discretion of the court.
Yes.
Whether you file the application or you not file the application, the court has to see whether you have filed the written statement in the court or department, whatever it is, within 120 days, then the court can pass an order by giving the reason why the court is accepting. So that is, but only now here the question is you have not raised all the things. Now at the time of arguing, you was telling that it is not a proper service in terms of that. It is so.
No, it's taken, my lord, in the affidavit.
You're taken on.
Yes.
So now
I'm saying quite naturally, my lord, we want to file the written statement. Written statement affirmed, my lord, on 10th of July. But, my lord, somehow they did not file it. But, my lord, written statement affirmed on 10th of July. This application affirmed on 11th July, and, my lord, filed, my lord, the date, my lord, has already, my lord, seen, my lord, when it was, my lord, filed. So with 30th March, my lord, we are little, my lord, 1 or 2 days, my lord, there will be a problem. But with 16 May, my lord, there is no difficulty. And, my lord, I've seen, my lord, this is.
If you affirm it on 10th.
Yes, my lord, that is a.
Why you not enclose the written statement along with the application?
Where's the affidavit?
Why you not enclose the written statement with the application?
Somehow, my lord, perhaps, my lord, they never applied their mind to, my lord, being, my lord, but the written statement, my lord, here, my lord, I've checked, my lord, that's on 10th of.
Para 9 states otherwise. Para 9 of the application states otherwise. Para 9 of your application states otherwise. Maybe para 9 of the application states otherwise. Para 9 of your application. Ready
to be affirmed.
Ready to be affirmed. That's why extension was sought.
No, this, my lord, we can't, my lord, nothing can be done about, my lord, the affirmation, my lord. It's affirmed on 10th of July. So that is, my lord, not, my lord, something, my lord, which.
Okay. Yes.
May I make my submission?
So, my lord, my lord, my submission is, my lord, considering, my lord, Order 9, Rule 5.
That are you taken?
Yes, Order 5, Rule 9.
Order 9, Order 5, Rule 9.
Order 5, Rule 9.
Subclause 4, subclause 3, and
subclause, yes.
21.
Subrule 4, subrule 3, read with, my lord, Rule 21. My lord, that requires. And, my lord, here, my lord, judgment, my lord, this Rajda marble, Raijada marble, actually, my lord. Here, my lord, will find, my lord, this application was itself filed.
I will place, Raizada.
Statement.
Identity.
Here, my lord, will find. Application, my lord, was filed on 5th September, which is beyond the 120 days.
No. In the present case, though the defendant number 1, 2, 3 have affirmed their written statement, affirmed their written and the affirmed the present application 28, but have not taken any leave from this court to file the written statement in the department, have not brought the same on record. So that's the same of you.
Absolutely
My
identical.
my application is not filed beyond 120 days.
Application leave aside.
Yes.
But the
No.
written statement.
Yes, my lord, written statement, my lord, though my lord affirmed within
not
period.
filed.
Yes.
Yes.
My lord, question was, my lord, whether you could file the written statement without leave of court. Because here, my lord, it seems, my lord, is held that yes, you can file the written statement, then you come and take leave. Because I don't think, my lord, that was, my lord, really the practice, because you would have made an application, my lord, and then asked for leave to file the written statement.
Okay.
So here, my lord, also, my lord, supplementary affidavit, my lord, if my lord gives me leave, my lord, that written statement, my lord, is affirmed on 10th of July, and the supplementary affidavit, my lord, encloses, my lord, the written statement, my lord, which is affirmed on, my lord, 10th of July. So that is there, my lord. We have affirmed, my lord, a supplementary affidavit with
But
regard to
not filed along with the application.
Yes.
That will be. Okay, let me hear Mr. Karan.
Yes. No, supplementary attestation. The fundamental premise on which.
Just case dekhe do. My lord, kindly look at, my lord, one decision, my lord, of the.
Can I have a copy of the
No,
case?
no, no. My copy di kar le. We can share. My lord, here also. My lord, paragraph 12, my lord, analyzes, my lord, order 5, rule 21. And paragraph, my lord, 16 to 18, my lord, particularly. Because here, my lord, court did not direct them, my lord, how to serve.
Yes.
So, my lord, we are on the question, my lord, as to what will be considered, my lord, as the proper date of service of summons. If 16 May, my lord, then there's no difficulty. And, my lord, if it's 30th March, then, my lord, 28th July, my lord, would be the date, my lord, as to filing.
Okay. Anything further?
Is there a copy? Page
16 to 8.
16. I'll just very briefly reply, Your Lordship. The fundamental premise on which this entire application proceeds, your lordship will kindly take up the application once, straight away. Kindly takes para 3. I will just place 2 paragraphs. Para 3 and para 8 and 9, 3 paragraphs. Para 3 categorically states writ of summons along with copy of plaint was served on the plaint petitioner defendant on about 16th of May 2024. So insofar as receipt, insofar as service of the writ of summons is concerned, at least, at the very least, as on 16th May 2024, that is admitted. It is never the contention of the applicant, of the defendant in its application that the entire process of issuance of summons, writ of summons, was defective, was not in compliance with Code of Civil Procedure, etc. That is not a premise, that is not a ground that is made out. Had that been the case, why would they make an application for extension of time, etc., etc.? That question would not arose, because in that case, the issue of delay in filing of written statement, the running of 120 days, etc., would not have commenced. Be that as it may, insofar as 16th May is concerned, there is an admission. Now, kindly takes para 8 and para 9, your lordship. Your petitioner states and submits that the time to file written statement in terms of writ of summons was due to expire on or around 16th June 2024. 9, very important. The petitioner defendant states that the written statement has been made ready and ready to be affirmed. However, the same could not be filed due to the aforesaid reasons by 16th June, so and so. Now, kindly reads para 9 together with the prayers that have been sought in the master summons. Prayer is for, at para 12 also, prayer is for extension of time for filing of written statement. Time to file written statement by petitioner defendant be extended by 7 days.
Yes.
From the date of the order passed herein. So it is unequivocally admitted that as at the date of this application, no written statement had ever been filed. What they say is they did not attach the written statement. They do not serve or furnish the written statement by any mechanism. We subsequently obtained report from the department. Till August also written statement had never been filed. Now it is admitted that written statement had never been filed. Now the question is, may I hand up the report? Just the departmental report.
Yeah, admitted. It is
Not filed. Now the question is,
yes,
what is the effect of non-filing of written statement vis-a-vis filing of an application, taking the leave, etc., etc.? And in my humble submission, this issue is no longer res integra, at least as far as this court is concerned. Your lordship will once again take Raizada. I will not detain your lordship too much.
Yes.
Page 3, top paragraph. The court finds that though the affidavit was affirmed on 28th August 2024, that is within outer period of 120 days, this is the affidavit.
Where from you're reading?
Page 3, your lordship. Page 3, top.
Yes.
This is really the affidavit
Yes.
to the application. That is within the outer period of 120 days, but the application was filed on 5th September 2024 after the outer period of 120 days. Now, if 30th of March is taken to be the date of service of summons, then identical scenario can also be found in the instant case. The application was affirmed allegedly on 26 July, but it was filed on 30th July, 28 July, the outer limit of 120 days expired. But the application was filed 5th after the outer period of 120 days. The written statement affirmed on 28th of August Now, 28th of August is within 120 days. And the written statement here again in Raizada was affirmed on 28th August 2024, was also not placed on record. Mere affirming an affidavit of written statement without filing in court or department will be of no consequence. Now, your lordship will kindly come to the bottom of para 3. Admittedly, the defendant numbers 1 to 3 have not filed the written statement within 120 days. As per the record, no written statement is available on record. In the judgment relied by the defendant numbers 1 to 3, Pratishtha Commercial Private Limited, this court extended this time to file written statement on the ground that affidavit of written statement was affirmed well within outer limit of 120 days. But this court and another coordinate bench of this court held that mere affirming an affidavit will no consequence unless it is brought on record. In the present case, though defendant numbers 1, 2, 3 have affirmed their written statement and affirmed the present application on 28th of August 2024, but have not taken any leave from this court to file the said written statement in the department and have not brought the same on record. Identical scenario to the facts of this case. Now, even if I were to assume that the appropriate service, without prejudice to my subsequent argument, that the appropriate service was of 16th May, it is nobody's case that within 120 days, this written statement was ever filed. And the ratio of the judgment is the date of affirmation of written statement is of no consequence. And the reasoning is you might affirm it, keep it under your pillow. That is of no consequence. It has to be brought on record. Yes. Now, in my humble submission, the present facts are completely squarely covered by the ratio of this judgment. Yes. The written statement, even if I were to assume, was affirmed on 10th of July, it has never been filed. Accordingly, the question that it was affirmed within 120 days is of no consequence, no relevance, completely covered by the ratio of Raizada. The application filed with the department 5th September, that is after the outer limit. In the case of SCG, the Supreme Court categorically held this court cannot accept written statement after the outer period. In the present case also, the written statement is not on record. And the present application has been filed after the outer period of 120 days. Thus, this court does not find any merit in the application. In my humble submission, insofar as the ratio is concerned, that mere affirmation of written statement is of no consequence, but it has to be the filing of written statement, which is of consequence insofar as the permissibility of acceptance of written statement within 120 days is concerned. That applies in the case. Now, the second argument. Second argument is, although in my opposition, I have categorically showed a report from the department that, in fact, by speed post, the writ of summons was served on the first address in the cause title on 30th of March 2024. This is at page 14 of my opposition, Your Lordship.
Yes.
Page 14, the second row, the second table, duplicate copy of the writ of summons along with copy of the plaint. Date of dispatch 21/3. For second address, undelivered. Now, third column, Your Lordship. Item delivered for first address on 30th March 2024. And what is the first address? The address of the sole proprietor, Virat Chandra Dagra himself. Principal defendant, the only defendant. Principal place of business.
Yes.
That was served. And there is, Your Lordship will find, no denial of this service. This service has never been assailed. Even in the application, and I looked up the affidavit in reply, there is no, this service has never been impugned. It has never been assailed.
Yes.
So at this stage, at the stage of an application for filing of written statement across the bar, this proposition that the entire service was bad, accordingly nothing was done, the time never started running, is completely contrary to the fundamental basis of the application, as well as the report that is on record at 14th. Now, insofar as the rules are concerned, Order 5, Rule 9.3, Rule 9.4, your lordship has been shown. And the emphasis has been court directs. Now, in original side, your lordship, this is not a business that is usually detained by the court. And under Chapter 6, Rule 12, master is invested with all the powers of the court, barring the exceptions. Your lordship will kindly see the exceptions. And this is not one of the accepted businesses. So if the master has taken a decision that it shall be served in certain way, then that is absolutely in compliance with Order 5, Rule 9.3 and Rule 9.4. Chapter 6, Rule 12.
Yes.
Rule 11 sets out what are the chamber business that can be business which may be transacted by registrar or master, exceptions. The registrar or master may transact all such business and exercise all such authority and jurisdiction as under these rules may be transacted or exercised by a judge in chambers, except where otherwise prescribed or in respect of the following proceedings and matters, that is to say, contested application, applications under Rule 11, Clause so and so, the making of an order for issue of warrant or committal, and also application and matter of proceedings under Chapter 12, Rule 1 and 6.
Yes.
This is not one of those proceedings. This is covered by Chapter 8. And under Chapter 6, the master is invested with the requisite trappings of the court. And the report of the master at page 14 categorically and conclusively shows that a decision was taken for it to be served by speed post and the fact that that service was indeed effected. That the fact that that service was effected has never been assailed anywhere on record.
Yes.
And in any event, through district court, your lordship finds on the top table, that has been accepted in their application itself. So the sum and substance of my argument is, even if 16/5 is taken to be the date, no written statement filed. So mere affirmation of written statement is of no consequence. If 30th March, which in my submission is also the date of service of the summons, at the principal place of business on the defendant is taken, then neither the application is within time, nor the written statement has been filed within the specific period of 120 days, statutory period. Now, one more case was cited by my learned friend on the last occasion. The 2022 Supreme Court, your lordship finds 2022 SCC Online SC 1512. The first paragraph itself gives out the point of distinction. Having heard the learned counsel for the respective parties in the facts and circumstances of the case and considering the fact that the written statement was filed on the 34th day. So that was a case when written statement had been filed. So the mere delay in filing of the application could not prevent filing of the written statement since written statement had been filed.
Okay.
In fact, the proposition is otherwise. Even if the application was delayed, had the written statement been on record, filed, not merely affirmed, then that would have been the proposition that is bolstered by the Supreme Court, not the other way around in my humble submission. Yes, in reply. In application regarding the 30th of March, your lordship, on the first day itself, I had pointed out, it was completely suppressed that there was at all any service affected on 30th of March. At para 3, they only mentioned 16th of May. Now in reply, at para 7, they deal with, after we pointed out and we furnished the report at page 14, they seek to deal with that at para 7, at page 5 of the reply. Now again, as I pointed out to your lordship, no denial of the factum of service. May I read?
A reply का है?
Reply.
Yes.
with reference to statements made in paragraph 7 to 9 of the said affidavit, save what are matters of record.
You are reading?
Para 7 at page 5. Dealing with para 7 to 9, because at para 9 I had made that statement. With reference to the statements made in paragraph 7 to 9 of the said affidavit, save what are matters of record, all allegations made therein are denied. I deny that any writ of summons had been served upon the defendant through speed post with AD, or the same is a recognized mode of service of any writ of summons upon the defendant herein, or that the duplicate copy of writ of summons could be served upon the defendant through speed post, or the same is a recognized mode of service as alleged, or at all. Moreover, I say that the alleged service of the duplicate copy of the writ of summons through speed post is not recognized in law. I deny that any writ of summons or the plaint was served on the defendant personally on 30th of March 2024, or the same is an accepted mode of service, 30th March, could be considered as the date of service of the written statement, or that the period of filing written statement so and so, as alleged or at all. I say that no service of the written statement had been effected so and so, and such service cannot be deemed to be a good or proper service as recognized procedure established by law. Now, apropos that, I have already made my submission. Order 6, Rule 12, read with the report that I have furnished, read with Order 5, Rule 9, 3 and 4. Those are my submissions. Anything else? Commercial side? And commercial division practice direction, commercial side practice direction is supplemental to the original side rules. And what I just referred to is the original side rules procedure. Those are my submissions. That is the law. The only factor that needs to be looked into is whether the written statement has been filed within 120 days, be it 16/5, be it 30th March. It has not been filed. That is an admitted position. Hence, it should not be taken on record.
Okay.
Those are my submissions.
Thank you.
Lord, just my lord, 2 sentences, my lord, in reply. My lord, the case has proceeded on the basis that, my lord, service was, my lord, on the 16th of May. That's, my lord, paragraph 9. So I don't know, my lord, why my learned friend, my lord, criticizes us, because paragraphs 8 and 9, it says 16th of May. And, my lord, 30 days, my lord, will be 16th of June. Therefore, my lord, the application made, my lord, for taking, my lord, leave. And, my lord, if my lord looks at my lord's judgment, then my lord will find at page 3,
With judgment.
my lord, the Raija, the marbles.
Yes.
Because, my lord, his sheet anchor, my lord, is this judgment, it seems. So, my lord, looks at, my lord, page 3. This court finds that though the affidavit was affirmed on 28th August 2024, that is within the outer period of 120, but the application was filed on 5th September 2024. That is after the outer period of 120 days. The written statement affirmed on was also not placed on record. So 2 counts, my lord, considers A, the application was filed beyond outer limit, and the written statement was also not affirmed. So, my lord, I could have, my lord, gained by either, my lord, I filed the written statement within 120 days, or I made the application within 120 days. Now, here, my lord, if the 16 May date is considered, then, my lord, no difficulty, my lord, the application is, my lord, made within 120 days. Written statement, my lord, may not have been filed, my lord, that is, my lord, with us, but, my lord, the application was made, my lord, within 120 days.
Okay. ये साढ़े 11 है क्या मैटर? साढ़े 11?
Grateful.
Heard orders शाम को आज ऑफिस में. Hearing concluded. शाम को आज ऑफिस में डिक्लेरेशन दे.
Grateful.
I'm very deeply obliged, Your Lordship.
Thank you.
And
Grateful to my
GA1
learned friends to permit me to argue.
facilitated.
প্রথমে এসে বললো যে না আর্গিউ করতে পারবে না।
I'm facilitated.
My lord, the supplementary affidavit, my lord, is on, my lord, may I just...
It's not ready.
Yes, next.
And
Grateful.
And GA1 may be made returnable because the other.
After
Very well.
disposal, let us see which way the court can go.
I'm deeply obliged.
Before the 11:30 matter, my lord, just item number 9, I would be taking a time to file a reply, my lord, and the interim order has to be extended, my lord. I am just out of time, my lord. I have already prepared the
You are for
reply.
the plaintiff.
I'm for the plaintiff. Well, this is your lordship's last order. My learned friend is on
Who is
the
for
other
the
side.
other side?
My learned friend is on the other side, my lord.
Dependent on
Let affidavit in reply be filed within a week. But at this, I'm asking just 1 more week extension to be on the safer side.
And till which date the interim
Kindly
order?
come to next page, 7th of March.
7 March.
Yes, sir.
After Raja, the Bahubali has come. Item number 9, huh? So appearing for
This
the
is
plaintiff.
part 1 Bahubali. Wait, another soon.
Another will come.
Appearing for the defendant. Counsel for the plaintiff prays for extension of time to file affidavit in reply. Let affidavit in reply be filed within 1 week.
1 week.
Within 1 week. Counsel for the plaintiff submits an interim order granted earlier is going to be expired on 4th of March 2024-5. Accordingly, prays for extension of the interim order. In view of the submission made by the counsel for the plaintiff, time to file affidavit in reply is extended for a period of 1 week. Full stop. The interim order is going to be expired on 4th of March 2025.
7th of March, probably.
7th of March 2025 is extended till 21st of March 2025. List the matter on 18th of March.
Obliged.
Grateful.
Item 5. Jagriti. Yes.
My lord, we were wondering, since I am rejoining, we were wondering, my lord, how to address your lordship, how to make it as concise as possible. Because after all, my lord, at the end of the day, officer of court, I have to do justice to my clients. Well, my learned friend on the other side has been pleased to refer to 32 judgments. My lord, it will be axiomatic to say that none of them are relevant. So if I start dealing with each judgment and I take 2 minutes,
60 minutes
straight. So, I mean, it is, I don't have that legal acumen to say that read the whole judgment. So even basic, how would that judgment apply? Well, this is the problem. So what we've done is, well, to the best of our ability, what we've done is that we have confined the judgments into 3-4 categories. Set of judgments relating to fraud, judgments relating to res judicata, and this is the way we've done it. So, but kindly indulge us a little on that, my lord. Otherwise, we're not either, because if I don't refer to certain basic facts which they have naturally, but he had every right to address your lordship on that.
This matter, I have given my rejoinder. I started, my learned friend started first.
Yes,
I made my submission.
Correct.
He gave his submissions.
How
I
did
made
I?
my rejoinder. On the last matter was going to be reserved. My learned friends just thought time to distinguish the new judgments which were given, the 2-3 judgments on res judicata. Now, if you want to reopen on facts, then
no, that will
no. Let me clarify this. Initially, the matter started on a different perspective altogether. Then I raised the point of maintainability. I addressed your lordship on the proviso to Order 21, Rule 58. I said that the petition is not maintainable. So, well, on maintainability, your lordship heard me. He responded to the point of maintainability. I am rejoining that. So, the main matter I am not addressing. Nobody has addressed your lordship on the main matter. So, we are entirely on the point of maintainability. And today I will again address your lordship, deal with whatever they have said, why the petition is maintainable. Only in respect to that. Well, not allow me to start. Well, the first limb of my learned friend's submission has been fraud.
My lord, when he says fraud, to the best of our understanding, what my learned friend wanted to say, or their contention is that the arbitral award, enforcement of which we seek in the execution proceeding, is a product of fraud. Now, so you have to make out a case of fraud today, assuming that it's a case of fraud. So you have to make out the case of fraud. He says, who is saying he's a fraud? Again, we come back to the maintainability point. It's an arbitration proceeding between A and B.
Correct.
A does not say it is fraud. B does not say it is fraud. C, who says,
aiming to be the beneficiary.
yes, that I am the shareholder of B, I say it is fraud. Now, when they say fraud, your lordship will kindly see, there is no allegation that the arbitration proceeding or there has been any fraud in the arbitration proceeding. No. Basically, what they say, if your lordship really looks at their pleading, it is collusion.
Because of that collusion, the letters was written, it was placed before the arbitrator, and arbitrator has considered that letter and
Pass the award.
That is the...
So now your lordship will kindly see, the arbitrator, if your lordship will see, lordship must have seen it, the arbitrator is a retired Supreme Court judge. And he had accepted the appointment as the arbitrator 1 month after he demitted office from the Supreme Court. Everything was before him, including all these letters. Now, interestingly enough, appears to be that he doesn't understand any of those letters. So, today, if your lordship will kindly contemplate a situation, somebody comes before your lordship with a plaint, no defendant. Will your lordship give a decree without looking at the plaint?
Yes.
So, my lord, adversarial litigation doesn't work that way. That's why we go to the judges or the arbitrators. So, my lord, their very contention, in my respectful submission, is a complete non-starter. There is no case of any fraud.
Okay.
His interpretation of the Reserve Bank of India, well, that Ministry of Finance document by which authorization was given to Starlight, which is the Mauritius company, to invest in India to the extent of 10 million and in 5 million in a step-down subsidiary. Well, this is a issue which is an interpretation of the document of the Ministry of Finance and the press note 2. According to him, press note 2 doesn't apply. But according to me, it does. But the arbitrator has held that it does. So that's why he gave an award that you are liable to make that investment.
Yes.
So the award. So, my lord, this bogey of fraud vitiates everything. Well, nobody disputes the proposition that fraud
That
does.
is the case he has made out with regard to the fraud. That's the main argument. It is a fraud, and that this court cannot, on the summary way, it cannot be decided.
Correct.
It has to be decided. That is the main crux
So
of the
now, my lord,
argument made by Mr.
prima facie, the court has to see,
That's
is
what
there
the
any,
court has-
is there
court
really
will-
any
court-
fraud?
Court will see, no problem.
So now the question is that, well, then my question is that, does this court has already seen that?
Correct.
Now, my lord, he has then referred to a list of judgments that res judicata doesn't apply. And your lordship will see all these judgments relates to jurisdictional issue. Jurisdiction, inherent lack of jurisdiction. Now he says that unless the matter is decided on merits, res judicata principle doesn't apply. I will come to those judgments. The judgment that has been referred in one judgment is in respect of a matter in an issue where the matters were dismissed for default. Now the question of this fraud, this bogey of fraud, arises out of what? He says it's a collusion between whom? Between the directors. Now, kindly have a look, kindly see how, if your lordship has to examine that, yes, it is a case of fraud. Just because I say fraud doesn't become a fraud. So your case of fraud is that
your directors, it is your company, you're the 100% shareholder of the company. So your directors have colluded with my company. So, my lord, your directors have colluded. So your directors are not a party here. Now, kindly look at the fundamentals, if your lordship will see. So you are alleging collusion by the three directors, your own directors. When you are the shareholders, my lord, under the companies, or your lordship is well aware, you had every right to hold an extraordinary general meeting and remove the directors, appoint new directors. You chose not to. Now, instead, what happens? These directors take certain decisions which you say is collusive. And I'm just giving the broad. So, my lord, where is the question of if there is collusion? It is your own person who has colluded. So, my lord, this issue has been extensively examined by the division bench of our court in the rejection of plaint appeal. Now, my lord, your lordship,
that is the point he has raised with regard to the court, the order initially passed by this court, partly allowed Order 7 Rule 11. Subsequently, the Honorable Division Bench, totally it has been allowed.
Right.
Setting up that this suit has been dismissed. So their main contention is that in that case, this court or the Honorable Appellate Court has not gone into that merit of the matter.
Right.
Only the court has gone into merit of the matter whether the suit is maintainable, challenging the award passed by the arbitrator. That is the point. As the argument made by Mr. Ingora. So he said that the court has only taken into consideration with regard to the maintainability of suit whether the award passed by the arbitrator can be challenged in the civil suit, and not gone into the fact, not gone into the merit of the case on what ground they have challenged there. So the ground has not before either before this court at the time of hearing of Order 7 Rule 11 or before the appellate court. So that's why it is not a res judicata.
Also said,
so that is the argument.
So I'm so deeply obliged, my lord. 2 paragraphs of the division bench judgment will answer. Now, what the division bench, the plaint rejection was on the ground that the plaint does not disclose a cause of action. Well, here is not a question of jurisdiction or barred by law. The issue in the rejection of plaint and the appeal was whether the plaintiff has a cause of action or not. Now, the division bench, I'll just show your lordship a few paragraphs from the division bench order. Division bench examined the case made out by the plaintiff and came to a conclusive finding that the plaintiff does not have any cause of action to pursue that action, and the plaintiff does not disclose a cause of action. And my lord, if the plaintiff then did not have a cause of action, how does the plaintiff has a cause of action now?
Okay.
Identical situation. So there has been no change in situation.
Okay.
What you challenged there, I will show you, lordship. My lord, award was one of the challenges. Prayer D. Prayer C, I stand corrected. My lord, just a few paragraphs from the division bench judgment. If I may just trouble your lordship.
Page.
My lord, if I may just page 67 of our affidavit in opposition.
Affidavit in opposition.
Yes, man. Our opposition to their. No, this is not our opposition. Yes, our opposition to GA1. To GA1. Will be with the back sheet of Sanjay Ginodia.
Jagdish Sharda, 28 March.
Yes. Affidavit by Jagdish Sharda. Yes, ma'am, it is. If my lord kindly take straight away paragraph 36 once, page 85, running page 85, 36.
Yes.
It is possible to imagine several scenarios where an arbitral award or a decree of a court is made against a person, but it affects another who was not a party to the arbitral reference or to the suit. Clearly, in such a scenario, such a person cannot be proceeded against in the enforcement of an arbitral award or execution of a decree. Now, the fallacy in the plaintiff's case here is that they claim to be affected or prejudiced by the arbitral award or the enforcement thereof in course of the execution proceeding instituted in the court. Legally speaking, the award of such and such was not rendered against the plaintiffs or either of them. Again, the arbitral award was not enforced against the plaintiffs or either of them. Clearly, the arbitral award was against the pro forma defendant, and it was also enforced against the pro forma defendant, which is the judgment debtor here. And the money went out of the bank account of the pro forma defendant. Yes. If at all, the plaintiffs are to blame for the circumstances in which they find themselves, it is the plaintiff's admission that the third defendant was appointed on the board of the directors of the pro forma defendant. Pausing here for a moment. So today he is alleging collusion of the directors with my company, the decree holder. And he wishes to get that same issue re-examined in the present proceeding, which he alleges to be under Order 21, Rule 50. Allow me to read on, my lord. Though the plaintiffs claim that there were other directors on such board, but upon the resignation of such directors, the third defendant came to be the sole surviving director of the pro forma defendant. Ordinarily, there cannot be a single member board of directors of any company. And when a director finds himself to be the lone member of the board of the company, usually such director has the power and authority to induct another, and thereafter for the two together to co-opt or induct further directors that the articles of association of the relevant company may provide. Now, my lord, kindly see. Without being overtly critical, it is plain to see that there is no legal basis to the claim of the claim in the plaint. So we are pausing here for a moment. If you don't have a legal basis then, how would you have a legal basis now? But we have seen the plaint case and their case now are identical.
Yes.
For instance, the plaintiffs claimed such and such. Kindly see, the meeting was also considered. That the plaintiffs held a meeting on 15 December 2009 and revoked the authority of the third and fourth defendants as the signatories to the bank account of the pro forma defendant. Ordinarily, such authority to designate an authorized signatory is a management activity which is entrusted to the board of directors of the company and the shareholders of the company. Even all of them as a collective cannot usurp such authority. Well, pausing here for a moment. Well, this is the finding of the division bench. Well, now he's asking, well, a single bench of this court to once again re-examine the same issue.
Yes.
Would not the principles of res judicata apply? Is this not a finding on facts?
Yes.
Again, the plaintiffs claim that they held an extraordinary general meeting on such and such. However, ordinarily, general meetings of the company, including any extraordinary general meeting, is convened by the board of directors of the company and not by the shareholders. Though the shareholder of the company can requisition a meeting and subject to the articles of association of the relevant company and the provisions of the governing statute, the board of directors is obliged to convene an extraordinary general meeting upon a notice on such regard being issued to the requisite an extraordinary general meeting. Then, my lord, on a most charitable reading of the plaint, which is what is required in a court in season over the objection and a notice of demurrer, it discloses no semblance of any cause of action against any of the defendants, whether in respect of the arbitral award My lord, kindly make the note of the rest two words, or otherwise. So court wasn't really examining whether his right to challenge the award could have been there or not. I would have understood. Entirety of his claim in the suit, which included the third relief that he claimed in the suit, which I wish to now draw your lordship's attention to, was examined. Then, my lord, as noticed above, only the party aggrieved by an arbitral award may challenge an award. The plaintiff are the parties to the award. At any rate, no suit is maintained to challenge the award. This is one aspect. Now, my lord, kindly have a look at para 39. In the light of the above discussion, it is completely unnecessary in the present context to embark on an exercise to discover whether it is permissible to partially reject the plaint. The plaint in this case cries out to be rejected in its entirety as being an animal that is not known to legal science. So how would this cause of action now be carried in a proceeding under Order 21, Rule 58? Because his case, what I'm trying to say respectfully is, what he is trying to agitate is not recognized in law. Whatever other remedy may be available to the plaintiff against the defender, plaintiffs are not entitled to any of the reliefs. My lord, kindly make a note of this. Claimed in the present suit, even if all the allegations in the plaint are accepted at face value. Expressed in another way, the plaint plainly does not disclose any modicum of cause of action. The plaintiff is not legally entitled to canvass any of the reliefs claimed. The plaint is liable to be rejected. Rejection is the plaint as a whole.
Yeah.
Matter goes to the Supreme Court. Supreme Court dismisses SLP. Now gives them liberty. Now, in my respectful submission, this liberty is sought to be misinterpreted. Now, I have shown your lordship a judgment. Now, what happens? My learned friend refers to Kuni Ahmed. Doctrine of merger. Now, but the fact that this division bench judgment, if SLP is dismissed at the threshold, doctrine of merger does not apply. But the doctrine does not say that the division bench judgment disappears. It is a precedence. This adjudication of whether the plaintiff had a cause of action or not is still subsisting. So this division bench judgment has been affirmed by the Supreme Court. On the SLP special petition having been dismissed, now let's kindly have a look at the Supreme Court, that liberty, what he is trying to say. What liberty was given to him? He says that at that relevant point of time, execution proceeding was pending. So when once liberty is given, liberty doesn't mean that you have a right, whether it is recognized in law or not, to pursue the remedy. So I have shown the judgment to your lordship, my lord, Asgar, that judgment of the Supreme Court in Asgar's case, where Supreme Court said that when liberty is given to you, so that liberty also applies to the other side to also contend that the action that you have brought is not maintainable. That is exactly what we have said. Now, my lord, kindly have a look at, he says, kindly look at, I'll just read out for your lordship's consideration quickly, the third prayer in his plaint. He says the suit was only not for setting aside of the arbitral award or for the purpose that the arbitral award was the product of fraud. That's his case in the plaint. Your lordship will kindly see prayer C of the plaint.
In which GA?
I think it is what was handed over to your lordship, the plaint.
of judgments.
Can I just give it to your lordship?
Yeah.
Well, this is a plaint filed in CS number
284.
284 of 2014. Well, kindly take internal page 40 at the, your lordship will find the pagination at the bottom of the page. Page 46. The prayer starts at page 45. First is the declaration that the purported award is non-est, then delivery up and cancelled, and kindly see C. Well, kindly consider C. Declaration that the defendant number 3, 4, and 5. Who are 3, 4, and 5? Directors.
Yes.
And each one of them had or has no authority to represent the pro forma defendant. Who is pro forma defendant? Well, kindly have a look at the cause title ones. Pro forma defendant is Augusta Zavani, which is the judgment debtor here. Or to take any steps on behalf of the pro forma defendant.
Yes.
Page.
Declaration, defendant number 3, 4, and 5.
And my lord, kindly take once. Page 35. Paragraph 41.
Page 35.
Page 35, para 41 onwards.
Yes.
Kindly take the bottom para 41. Kindly see this, my lord. The plaintiff states that the defendant in collusion and conspiracy with each other have perpetrated fraud on the plaintiffs through the pro forma defendant. Pro forma defendant, the judgment letter here, and also on this honorable court. Particulars of such for perpetrated A, B, C, D continues. So, division bench has held that you don't have the cause of action to carry your action for fraud and come to that conclusion. So, basically, my lord, it is the third bite at the same cherry. Interestingly enough, now your lordship, when we were addressing a lordship on Order 21, Rule 58, we said that designedly when the execution proceeding filed, they came to know instead of filing Order 21, Rule 58, they chose to file a suit. My lord, we are extremely grateful to my learned friend. He had pointed out the Bombay High Court proceedings. If your lordship be correct, he started with the Bombay High Court. Kindly have a look at the Bombay High Court order. Now, I'll tell you, lordship, what happened. Bombay High Court, 2 writ petitions were filed. What was the initial stage? My lord, their checks were issued. And my lord, there were 2 letters which were written by the shareholders, which is my learned friend's client, the Mauritius company, to the Hong Kong and Shanghai by HSBC, on the basis of which the accounts were frozen. Now, one writ petition was by them and the other writ petition was by us. Now, I am on the writ petition which was by them. So, my lord, your lordship will see. So, which checks are these? These are the same checks, which was my cause of action. Checks for the purpose of the same 50 million, 5 million. Now, my lord, the Bombay High Court, my lord, kindly have a look at. So, you had knowledge of the entire proceeding from 2011. This issue that your directors, according to them, who has gone rogue, that your directors were acting against the interest of your shareholders. So you were aware of this situation since 2011 when we went before the Bombay High Court and you filed the writ proceedings. So one paragraph from the Bombay High Court's judgment. No, I stand corrected. I just stand corrected.
We have not. You've been pleaded by the Bombay.
Impleted. I stand corrected. On an application filed by them, they were impleted.
The High Court so moto because the director and national on the Bombay High Court. The bank told the Bombay High Court that this is the situation. The Bombay High Court pleaded us, and then we entered appearance. So we have not moved the Bombay High Court.
Very well. So you had knowledge of the proceeding. I'll just show your lordship one paragraph from the Bombay High Court order. Bombay High Court order. Yes, well, kindly take page 138. Yes, Bombay High Court, 138 of their application.
138
of their application.
Yeah.
Eight. Page. Yes.
Yes.
So, well, technically I'm not wrong. Your lordship will see who's the writ petitioner.
Augusta.
Writ petition is Augusta Zavani Land, which is the judgment debtor company.
Yes.
It was their writ petition. So it was. So if you say you are the shareholders, so you cannot have an independent right. Man, I don't want to go to Bacha Gazdar. Man, we know it too well now. Man, too well settled the principle to be addressed also. So it was the writ petition by the judgment debtor. Now, man, kindly have a look at the first paragraph that speaks for itself. The second respondent, HSBC, is in a communication, issued a communication to the petitioner on such and such, and the bank had refused to honor two checks of 15 crore and 5 crore, respectively issued by the first petitioner on the basis of certain instructions which were received from two shareholders of the company. Before this court is not disputed by counsel appearing on behalf of the second respondent that under the present mandate, the bank petitioner must be authorized. Since the bank has acted at the behest of two shareholders, we are of the view that the interest of the justice will require that those two shareholders are heard before final orders are passed in the proceedings. So, acted on the basis of the shareholders' instruction. Now, my lord, they get added. Now, kindly, my lord, by this petition, they get added. Next page, your lordship will see Starlight, which is my learned friend's client. At the next page, we grant leave to implead Starlight. Starlight gets added. Now, kindly come to page 140, which is the final judgment. My lord, kindly take para 2 at page 141. The account was opened by the first petitioner, HSBC. And my lord, kindly, if your lordship turn to the next page, altered from time to time, that's the signatory. And at present, the second and the third petitioners are according to the bank authorized signatories in this regard. Then, my lord, kindly come to I'll just show you, lordship, my lord, what the court held. My lord, kindly come to page 145. My lord, where the sixth paragraph commences, just about 5 lines before that, my lord, there's a para your lordship will find, which is running page 145, in the affidavit in reply. In the affidavit in reply, which has been filed on behalf of the third and fourth respondents, reliance has been placed inter alia on the resolution passed at the EOGM of the first petitioner held on such and such, by which the authority of the second and the third petitioners to operate the account has been revoked. Then, from the material, the final conclusion is here. My lord, 146, middle of page 146, the second, third, fourth petitioners claim to be the directors of the first petitioner, and the second, third petitioners claim to be a mandate to operate the account. Whether the second, third petitioners have a mandate, which is valid to operate itself is a matter of serious dispute, since the bank has been informed of the resolution on the basis of which, in view of the matter, we are of the view that Reserve Bank of India such and such. Then, my lord, kindly turn to the next page. What does the court say? My lord, we cannot go into that. It should be resolved by a competent forum.
Correct. We therefore decline to
Yes,
exercise.
the jurisdiction of 226 cannot be exercised to decide a dispute about internal, my lord, kindly make a note of the internal management.
Correct.
So you are a party to a proceeding where your mandate to issue the check was itself an issue. So you are aware since then, and your lordship will see the first order at page 138 was passed in November 2011.
Yes.
Now, what did you do about the mandate and the proceedings? You did nothing. Now, your lord, I will show your lordship. Kindly take once page 150. So the Bombay High Court refrained from exercising its jurisdiction, saying that this is the issue of internal management. Whose management? The judgment debtor company's management. It doesn't concern me. It is the judgment debtor company's management. So your management, you claim that your management has gone rogue.
Correct.
So you could have stopped your management in 2011 itself. You had the right. You were aware, conscious, everything.
Yes.
Now kindly, so that was his first bite. That was his first bite. He did nothing. Then kindly take page 151. Now this is my writ petition. Ascot. Now, my lord, Ascot is the...
Ascot in there. That's the whole collusion.
What is the collusion? Now, my lord, let me address this collusion. Let me address this collusion. What you think is collusion is the reality. Realities are never collusion. Ascot is the JV, the beneficiary. So if two companies come together to make a JV, and if I'm working towards the JV, is that a collusion? So why did you come together to make the JV? Why did you apply to Reserve Bank of India for an investment in an Indian project?
Yes.
So those were never collusion. Not kindly have a look at the writ petition which has been filed by Ascot. But here what happened is, well, the account frozen issue was taken to Ombudsman, Appellate Authority, challenged. Now, well, interestingly, well, this is by Ascot, which was the beneficiary of the money.
Correct.
Now, if your lordship will see, once kindly come to page 152, there's a quoted portion.
Yes. Freezing account has been done by...
This is what the Ombudsman had held. The freezing of the account has been done by the bank on the basis of a board resolution and not at the request of a shareholder. So, Ombudsman said nothing doing. Then, now kindly see what the High Court says. There were 7 and 8. Now, my lord, the shareholders were respondent number 7 and 8 in this proceedings. Now, my lord, kindly have a look at page 154, absolutely extreme bottom of page 154, para 10.
Yes.
In our view, there is much substance in the submissions made. Now, my lord, I should have just indicated once, my lord. This is my, I shouldn't have missed it. My lord, kindly once take page 153, para 9. On the other hand, counsel appearing on behalf of the respondent number 7 and 8. That is my learned friends' clients. As also the counsel for the bank urged that the two checks, that is Augustus Avani Land and others, had filed a writ petition in this court seeking some relief. writ petition before the ombudsman, then my lord, the writ petition, then the special writ petition that went up from the writ petition, everything considered, the previous writ petition filed by the judgment debtor. Then it comes to this conclusion, which I was placing, paragraph 10 towards the bottom of page 154. Now it says, in our view, there is much substance in the submissions made by the senior counsel appearing on behalf of the petitioner. Perusal of the impugned order clearly discloses that ombudsman had proceeded on the footing that action for freezing the account has been taken by the bank on the basis of board resolution and not at the request of the shareholder. This reason obviously is not correct in view of the reply given by the bank to the RTI query, which was made by the petitioner. That being the position, in our view, the impugned order and the order which is passed by the appeal based on this fact will have to be set aside. So far as the submission of the counsel appearing on behalf of respondent number 7 and 8 and the counsel on behalf of the bank is concerned, in our view, the submission cannot be accepted. The division and which court had, while dismissing the petition, declined to exercise jurisdiction. And what had happened is, my lord, this was based on the shareholder's request. Ombudsman proceeded on the basis that no, it was based on a board resolution. So it was correct. So that's why both the orders were set aside. So this was effectively, my lord, the next round that they faced. And this round, my lord, happened and came to a conclusion, my lord, in 2014. That your lordship will find the date at page 150. The judgment of the Bombay High Court at 8th of January 2014, which is the writ petition filed by the present decree holder, the award debtor. Then, now, my lord, kindly see. So, my lord, his submission that I was completely unaware. So, he all along had a right to challenge at whatever stage, because, my lord, his challenge as a shareholder was never maintainable as against the decisions taken by his own management. That decision is not sustainable in law.
Yes.
But otherwise, my lord, it will lead to an anomalous situation.
Yes.
Tomorrow, my lord, Tata, see if I have shares in Tata Metallics, substantial shares in Tata Metallics, or say any group company which makes an investment in a foreign, say a foreign steel plant or a foreign joint venture company. And I say that no, this investment will result in a loss. And it eventually results in a loss. Can I say that the management decision was fraudulent?
Okay. Next.
So now, my lord, he had made a lot of submission on the press note. My lord, I'll just indicate only one thing.
Already argued on that.
No, my lord, your lordship will see those two documents. I'll just give your lordship the page numbers. My lord, the original sanction that was given, that was, my lord, project specific.
Correct.
Press note 2 says project specific. Their investment was in real estate project, and press note 2 refers to real estate project. That is why. So now you today cannot turn around and say, which you did in course of your arguments, while countering my arguments on maintainability, that the arbitrator did not consider this. Arbitrator did consider and did come to the right conclusion. That you cannot allege to be fraud. Because the interpretation of his press note, in any event, that press note has subsequently been clarified by the Ministry of Finance. So, my lord, those submissions this does not deserve any countenance at this stage, at Order 21, Rule 58 stage.
Yes.
Now, my lord, this in limine dismissal of Supreme Court ballot is of no consequence, because the liberty has been given. That liberty does not give him any additional right in law. Now, my lord, they have made submissions on two additional points, which was limitation and corporate veil. My lord, corporate veil. My lord, if your lordship will see, my lord, this is a self-destructive argument. My lord, there's no dispute on the fact that there is a joint venture. So, based on the joint venture, the arbitration proceeding commenced.
You're right.
So it is not your case that the joint venture agreement is fraudulent, or there exists no valid arbitration agreement. Then I could have understood the question of jurisdiction would have come. Section of 47 comes. Section 47 could have come. There is no arbitration agreement. How did the arbitral award pass? Inherent lack of jurisdiction issues would have come. Lord could have entertained that. But that is not his case. His case is collusion of his own directors. So, my lord, this issue of corporate veil, if there is no fraud, where is the question of the lifting of corporate veil? JV accepted. He says same address. Naturally, it has to be the same address.
Yes.
Attempts are made to prejudice your lordship based on the address. It has to be the same address because I am the joint venture company. The joint venture is with me. So if I come together to form a third company, so it is but obvious that there has to be some commonality. So how would you use that commonality to the prejudice of one of the companies who is a party to the joint venture?
Yes.
So, my lord, in my respectful submission, their argument so far as lifting of corporate veil concerned has no manner of, does not deserve any counter. And my lord, significantly, rightly pointed out, your lordship can take judicial notice of that. These directors still continue. I don't want to go to the history of directors, how it happened. Not removed till date. His alleged directors which against the interest of the shareholders, acting against the interest of the shareholders.
Yes.
My lord, at this stage, my lord, my learned friend on the last occasion, I am told, refer to the NCLT orders. My lord, kindly make note of two things. The NCLT, when was the NCLT proceeding initiated? Your lordship will see. And when were the orders passed? After I concluded my submission, they rushed. They realized. So if the NCLT orders have passed in 2025, and arguments in this proceeding have commenced from the month of May 2024, your lordship can understand it's a right they have. I will not say it's an afterthought, but the fact that you did nothing in that proceeding which has been pending for over 10 years, and you just activate the proceeding, NCLT gives you relief.
You can
in a company proceeding. You're most welcome to enjoy those reliefs. Remove directors, whatever. So, my lord, you cannot, my lord, substitute the NCLT jurisdiction with a jurisdiction of a court entertaining an execution arising out of an arbitral award, which is now a decree of a court.
Yes.
Yes. Now, my lord, one more submission was made regarding venue. And they say that that is also collusion. Well, they say that the venue was under the ICC rules in Singapore. Well, the arbitration started in 2013. So the laws as prevailing in 2013 would be applicable.
Yes.
When the arbitrator accepted appointment and commenced the reference, he could not have perceived after 7 years what the Supreme Court would hold. So we have to proceed on the basis what was the law in 2013. Well, kindly take once the Arbitration Act. Well, it could have been, well, both the parties your lordship will see under the joint venture are both Indian companies. In order to be a foreign arbitration, well, kindly have a look at the Arbitration Act. আর্গুমেন্টটা কোথায় লেখা আছে? না, আমারটা লেখা কোথায় আছে? এত বেশি লিখে ফেলেছি, ওটা খুঁজে পাচ্ছি। Yes, I've got it. But kindly one see section 21F. मतलब 21F means an arbitration relating to disputes arising out of legal relationship, whether contractual or not, considered as commercial under the law in force in India, and where at least one of the parties is
India.
If it's an individual, any country other than India, he has to be a habitual resident. If it is an individual, in our case, it's a body corporate, which is incorporated any country other than India. So FII will apply to us, both the companies.
Both the companies
So in order to be an international commercial arbitration,
means arbitration relating dispute relation. Individual who is the national of origin, it is not covered.
Correct.
Body corporate which is incorporated in a country other than India. Associate body India. Yes.
So in order to be an international arbitration, it has to be either Roman 1, 2, 3, or 4. So these are both the companies. So it has to be 2. So one company in any country other than India, incorporated other than India, kindly see the joint venture agreement. Your Lordship will see both the companies
Yes.
are, which is Jagriti Trade Services and Augustus, both are incorporated in India. Agreement pista bolo na. Kindly make a note of that page number once. 10 of the well, they have a reply. I'll just indicate to your Lordship the page number. Reply 109. First page of second volume. Their reply, my lord, first page of the second volume, page 109.
Yes.
I think it is 155. 155 of? Oh, thank you. My lord, kindly see page 109, my lord.
Yes.
Joint venture agreement. Kindly see the first name of the first party. Augustus Avani.
Yes.
Registered office. Maker Chamber, Nariman Point, Mumbai. Kindly see next. Jagriti. 6B Bentic Street, Kolkata. Incorporated in India. Both are incorporated in India.
Yes.
So there cannot be an international commercial arbitration. Now, my lord, they refer to 16.2. Of the agreement, which is there at page 137. Which refers to the sole arbitrator to be appointed, 16.2 at page 137, ICC rules.
That you are pointed out, yes.
So they say that what? See, Singapore arbitration, they have accepted and did arbitration in India. Could they have gone to Singapore? That arbitration would have been a nullity in the eye of law. Could it have been two companies incorporated in India? Now, my lord, that is one aspect. The other aspect is,
but it is given. If the clause is given in the arbitration
yes,
clause, then what will happen?
What will happen? Parties can come together in 2013. What would have happened in 2013? We cannot today look at the 2025 situation and judge that.
That is okay. That is okay. But
see, in 2000,
if your argument is taken as both the parties are the Indian party.
Correct.
And though the 16.2, it is in Singapore, but both the Indian parties agreed. So there is no difficulty.
No difficulty in law.
So what would be effect of the clause of 16.2?
No, my lord, if your lordship says there are not hundreds of judgments, which says that the parties had agreed to refer their disputes to arbitration, have it adjudicated.
That's why the Mr. Hingorani has made the case agreed to, not difficulty, but the agreed is connivance.
Correct.
So he has made a submission, and as per this, it has to be held in the Singapore.
Correct.
And the arbitrator was appointed, but with the communication of both the parties in connivance and collusion, it has been taken in India.
Right. So, my lord, if I take his arguments to be, assuming his arguments to be correct. So he says that there was a collusion. See, this is the collusion.
That's right.
Singapore, but they agreed to arbitrate in India. Would that make the award a nullity or void? In my respectful submission, it would have been the other way around. Had the parties gone to Singapore, that would never have qualified to be an international arbitration within the purview of the Indian law. Now assume for the sake of argument today, my lord, kindly, your lordship is facing several for enforcement of foreign award. Section 48 comes before your lordship.
That's why I'm asking this.
Yes.
question
So
to-
today, sir, I would have been in that position. I would have come to India to enforce the award. I go to Singapore, I get the award, I come to enforce the award. So the first point that Augustus, the judgment that would take is what? Nullity. You cannot enforce it in India. Why? Because it's not a commercial arbitration, international arbitration. I would have had no answer. Because 21F is the answer. It is not a commercial arbitration. It has to be, in order to qualify to be a international commercial arbitration within the meaning of 2F.
Yes.
One of the party has to be incorporated outside India. Individual resident outside India.
Yes.
If there is not, how would that be? How would that qualify to be international commercial arbitration? So both parties, in their wisdom, thought Indian arbitration. Arbitrator accepted authority jurisdiction, gave an award.
Okay.
Now today in 2025, well, in 2013, well, this seat venue concept was not there. Whatever was there in 2013. But here is not even that case. That parties agreed. So, well, there are several cases where parties had agreed to arbitrate in Chennai or maybe in Bombay.
That is not a question.
By consent. The moment there is consent, the jurisdiction can change. So the consensus is the ad idem consensus is the.
That's why Mr. Ingorani is not telling that it has been passed in the Indian in the India it is to be set aside. He is not. He is only the point.
Collusion.
Collusion.
Absolutely.
Let me just clarify that. With the permission of the court, if I may just clarify that arbitration is a construct, is the creation of consent. There's nothing to prevent two Indian parties to say, let a foreign tribunal, a foreign body conduct arbitration.
Correct.
Clause 16 does not say international commercial arbitration. It only says arbitration.
Correct.
So my learned friend is starting with the definition of international commercial arbitration, between the requirements into the clause.
No, that's why Mr. Bose is taking it into consideration. At that point of time, there is no concept of the venue and the seat.
But it's not it's the other way around. The clause does not, the agreement, joint venture does not talk about international commercial arbitration.
Okay, let me see. Yes.
So even if I say collusion, even if there was collusion, even assuming that his management colluded. So how would that vitiate the award?
No.
It is your own management. They have decided to go in for arbitration. That decision, you are alleging that decision to be a collusion. A decision taken by a management. He has a right, the management has a right to take decision. I need not tell you also. That decision you allege to be collusion. There's a completely reasoned award. And the award says you pay. So that's where it comes. The next point that has been
How
taken
much
by.
time you will take further?
My lord. No, I haven't started with the judgments here, my lord. Your lordship gives me some time for the judgments. I'll just run through them. We made a complete note of the judgment. I will not, it is not possible. Then I will take a lot of time. Your lordship can see I have not wasted one single minute.
My friend has raised, I've noted down 12 new arguments in a rejoinder, at least 12 minutes. to respond to.
My lord, I am dealing with his arguments.
My learned friend is not. My learned friend had taken 4 or 5 days. There's some arguments are repetitive, but there are 12 new points he's trying to raise, and I'll need to respond to that. That's the reason why the Honorable Court on the last date was saying we can confine ourselves only to the new judgments.
I could not have.
Getting new points, I can list them out. And there's some misreading of the pleading.
Okay, come on the.
I will come with a note. I will just give me not
only with
I will,
regard to distinguishing the judgment.
Correct.
Because this all argument is
Yes,
already
yes,
made
yes,
by the parties.
Correct. I will come with a complete list with a note, give it to your lordship and finish it.
Then I would like to respond there on that date or the.
What?
No, I need at least 5 minutes just to respond to what my learned
Very
friend said.
For what?
My learned friend today. I'll just take one second or one point without opening the brief. If my court may just hear me.
Otherwise, the argument will not be completed. If it will go like
That
this.
is what my respectful submission is.
No, what you made the submission is clarifying that nothing new argument has been come. Okay, let us see. Let Mr. Bose complete. So and so appearing for the plaint petitioner and decree holder. So and so appearing for the judgment debtor. Full stop. Counsel for the decree holder has argued at length, but due to argued at length in reply. But due to paucity of time, hearing could not be completed. Accordingly, case is adjourned. Let the matter appear. Then it will go to April only. क्या डेट है? कितना बजे? 2 डेट दे दूं? 28th and 29th April at 3 p.m.
3 p.m.
The parties are directed to come with the written notes of argument on the date fixed.
Deeply obliged, my lord.
Yes, next.
My lord, I appear for the petitioner, my lord.
Yes.
Madam, but I have been intimated that the no caveat certificate has been provided by the department, my lord. On the last occasion, in terms of your lordship's order, we have made publication in Mumbai and one in Hindi Delhi and one in English Delhi in compliance with section 283 subclause 3 of the Indian Succession Act.
Yes.
Now, my lord, the testatrix had died on.
Where is the will?
My lord, the will is at page 11.
What is the name of the testatrix? Shakuntala Devi.
Shakuntala Devi Todi.
Yes. Where is the name of the executors?
Executor, my lord, find the last page. Executor, sole executor.
Where is
her
the
son.
Name? Where is the name?
My lord, at page internal page 4 of the will. I hereby appoint my son, Sri Ashok Kumar Todi, as sole executor of my last will, who will be entitled to obtain probate from any competent court of law.
When she died?
My lord.
When she died?
She died on 16th July 2006. The death certificate is annexed with the petition at page 10, my lord, being the annexure A. My lord, the
July 2006.
2006.
And will dated 7 June 2006.
7 June.
Within a month. Yes. Where is the legal layers?
My lord, the legal layers are being mentioned in the will page number. Page number, internal page 2, paragraph 2.
What about the husband?
My lord, husband has predeceased him. Predeceased her.
Where is mentioned?
My lord, will you find the cause title of the petition that Shakuntala Devi Todi, wife of late Giridhari Lal Todi.
That's correct. Where is that? Have you pleaded predeceased?
My lord, that I find that is not pleaded, but in the will, my lord, internal page 2 of the will, it is categorically stated that I have the following sons and daughters, namely
Okay.
Krishan
Next.
Devi Todi and Rahul Todi as legal heirs and heiress.
How many consent has been filed?
Everyone has given consent, my lord.
Where is the consent?
My lord, the consent are there, my lord. Individual affidavits are being there, my lord. The Rahul, my lord, what has happened? Shakuntala Devi Shakuntala Devi had 3 sons: Kishan Lal Todi, Ashok Todi, Pradeep Todi, and 2 daughters, Asha Poddar and Sarita Agarwal. Now, Kishan Lal Todi had died after the death of Shakuntala Devi Todi, leaving behind, prior to Shakuntala Devi's death, leaving behind his 2 sons, Naveen Todi and Rahul Todi, and his wife, Prabha Devi Todi. So, my lord, everyone has given consent. Naveen Todi.
Where is the Prabha Devi Todi?
Prabha Devi Todi is no objection, is also there, my lord.
Where is the name appearing here? Not disclosed.
My lord, paragraph 5 of my petition, it has been stated that the aforesaid legal heirs Naveen Todi, Rahul Todi, Pradeep Kumar Todi, Asha Poddar and Sarita Agarwal have given consent to the issue of grant of probate of the last will and testament of blank by this honorable court in favor of the petition, and for abundant caution, one Prabha Devi Todi, being the wife of predeceased son of said Shakuntala Devi, also given her consent in favor of the petitioner, and the affidavit to that effect are annexed hereto and collectively marked with the letter C.
So all have given consent.
All have given consent.
Then
now, my lord,
where is the consent?
One of his son, Pradeep Todi, has filed the affidavit of the attesting witness and has also filed a declaration which will appear at page number 9 of my application.
Naveen Kumar Todi.
No, my lord. Pradeep Todi. Pradeep Kumar Todi. The son of the testatrix. Page 9 of my application. This is the declaration, my lord, and the affidavit is also there.
Is given no objection.
My lord, there is another affidavit of the attesting witness, my lord.
Where is who is the attesting witness?
Attesting witness is Pradeep Kumar Todi.
So where is that?
ওখানেই তো আছে একটু দেখুন না আলাদা আলাদা এফিডেভিট এক্সিকিউট করে না
आधा इसमें आधा उसमें क्या करते हैं यार? Then
there is another affidavit of Ashok Todi, the affidavit of assets, my lord.
Why Ashok Todi has given affidavit of asset?
Ashok Todi is the sole executor under the will, my lord.
The executor. Yes. So why the citations have been issued?
Well, citations have not been issued because everyone has executed a no objection. Everyone has given consent, my lord. Only when publication has been made pursuant.
So that's why publication.
Because one of the properties is situated in Mumbai. In terms of the affidavit of assets, my lord will kindly find that an immovable office at
Suffering for the petitioner. The petitioner has filed the present application for grant of probate of the last will and testament dated 7th June 2006 of the testatrix Sakuntala Devi Todi. Counsel for the petitioner submit that the testatrix has executed her last will and testament by appointing the petitioner as sole executor of her last will and testament. The testatrix died on
16th July.
On 16th July 2006, leaving behind 2 sons, 2 daughters, and 2 grandsons. Full stop. Counsel for the petitioner submitted. One of the husband of the testatrix was predeceased to the testatrix, and one of the son, namely Kisan Kumar Todi, was also the predeceased to the testatrix. Full stop. All the legal heirs have filed their affidavit of consent, stating that they have no objection for grant of probate to the petitioner. The legal heir or the legal heirs are also the attesting witness of the said will, out of which Mr. Pradeep Kumar Todi, being one of the attesting witnesses, has filed a separate affidavit stating that the testatrix has executed her last will and testament in his presence and in presence of other legal has executed her last will and testament in his presence and in presence of other legal heirs by appointing the petitioner as sole executor of her last will and testament while possessing good health and fit state of mind. Full stop. Counsel for the petitioner submitted. One of the properties situated outside the jurisdiction of the state of West Bengal, that is at Maharashtra, and accordingly notices are issued, but in spite of the issuance of notice, none has come forward to raise any objection, and accordingly the department has submitted no caveat certificate on 26th of February 2025. Consider the submission made by the counsel for the petitioner, perused original will, death certificate of the testatrix, affidavit of consent of all the legal heirs, affidavit of attesting witness, no caveat certificate, and no caveat certificate. This court find that all the legal heirs have given no objection, stating that have filed affidavit stating that they have no objection for grant of probate to the petitioner in terms of the will. Full stop. One of the attesting witnesses also categorically stated that the testatrix has executed her last will and testament in presence of all the legal heirs by appointing the petitioner as sole executor while possessing good health and fit state of mind. Full stop. Considering the submission made by the considering the above, this court find that the petitioner has proved the will and is entitled to get the probate. Accordingly, the department is directed to issue probate of the last will and testament dated 7th of June 2006 on completion of all formalities. At the time of grant of probate, the copy of the will be made part of the probate. PLA 96 of 2021 is disposed of.
Grateful manner.
Next.
133 will damn for the petition. But here is my supplementary affidavit.
33. Yes.
My lord, pursuant to order of 12th of December 2024, my lord, inventory took place, my lord. But my lord, the valuation has not yet been done as there was no order for valuation of the articles lying in the locker, my lord. But unless the valuation done, my lord, the amended affidavit of asset cannot be filed, my lord.
So now what you want?
My lord, I have filed the GA. My lord, GA1, there is my prayer, my lord. Prayer A and B of the GA. My lord, kindly come to page. I have annexed the GA, my lord, page 13 and page 14.
GA1.
GA1, my lord. Well, I have annexed the GA with the supplementary affidavit, page 13 and 14 of this affidavit, my lord.
Original annex original का GA. Where is the original GA?
The GA is the file. Check.
तो यहाँ है लेकिन ओरिजिनल कहाँ गया फिर? एफिडेविट सर्विस है, PLA है ना. What is your prayer?
The prayer A and
Where is the
prayer
master
B.
summon?
Page 13 and page 14 of the supplementary affidavit.
13 and 14. So locker is not yet open.
Yes, it was open, but valuer not assess the valuation of the articles, the gold ornaments and the silver ornaments which are lying with the locker. I have annexed the inventory report also.
So you want to value the property?
Yes, my lord, with a valuer as per the registration of the bank, my lord.
Where's the inventory?
My lord, at page 5 and 6.
5 and 6
of the supplementary affidavit.
So how the valuer will come?
Well, in the bank, there are some registered valuers.
So appearing for the petitioner. The petitioner has filed the present application being GA1 of 2023. Praying for a direction. Praying for leave. Praying for a direction upon the manager, Central Bank of India, Chetla branch. Address is correct. Then again it will be problem. Chetla branch.
Yes, my lord. It is Chetla branch.
Chetla branch.
Central Bank of India.
Chetla branch. That is only.
Only. The
Chetla
locker
branch.
is with the Central Bank of India.
Chetla branch. To value. To ascertain the value of the gold ornaments. Only gold, all other things are there. All gold and silver ornaments.
Silver ornaments are there.
Gold and silver ornaments available in the locker number. What is the locker number?
And locker number is earlier number is
number 47. Presently locker number. Locker number within bracket old 47, comma new 450 2122 022, lying in the name of the deceased Shwadesh Kumar Mitra, in presence of the applicant or his legal representative Counsel for the petition submitted. At the time of filing of the application, the locker number was not available with the details of local number was mentioned in the.
Yes, GA I have mentioned the number.
No, at the time of filing of the case, locker number was mentioned. Counsel for the petition submit that after opening in terms of the order passed by this court, the locker was opened and it was found that altogether 29 ornaments were available in the said locker, and as such.
No, my lord.
And as such, the said ornaments are required to be valued so that the affidavit and so that the value of the said ornaments should brought on record in the affidavit of assets. Considering submission made by the counsel for the petitioner, comma, the manager, comma, Central Bank of India, comma, Chetla branch is directed to to open the locker number 47 within bracket new number so and so new locker number 45021222022 lying in the name of the Swadesh Kumar Mitra in presence of the petitioner or his legal representative, and to get the said ornaments valued through the approved valuer of the bank in presence of the approved value of the bank, and to submit the report before this court within a period of 3 weeks from the date of receipt of this order. The petitioner is the full stop. The petitioner is directed to communicate this order to the manager, Central Bank of India, Chetla branch, for compliance. GA number so and so is disposed of.
Well, within 3 weeks, I have to come with the amended asset.
Within 3 weeks, he will submit the report. Then you come with whatever you
I'll
do.
need to apply for that.
Okay. Next.
Your Lordship, I am appearing on behalf of the executor. Your Lordship, we have taken out an amendment application, Your Lordship, pursuant to the notice served by this honorable court upon the attesting witness, from which we came to know that one of the attesting witnesses is alive, Your Lordship. We are in the process of filing it today. If Your Lordship kindly keeps it on the 12th.
As per the prayer made by the counsel for the petition, the case is adjourned. Let the matter appear.
Your Lordship, if Your Lordship.
As per the prayer made by the counsel for the petitioner, the case is adjourned. Let the matter appear.
On the 12th, if Your Lordship kindly keeps.
On 12th of March 2025. Yes, next.
Your Lordship, I am appearing for the petitioner. I am praying for 2 weeks' time to take the appropriate steps, Your Lordship.
Why?
Your Lordship, as per the last order, Your Lordship, it has been stated that 2 attesting witnesses have died, but we have not disclosed the death certificate, Your Lordship. We are taking steps to obtain the death certificate, but we have not get it right.
To proceed in December also, January, let the matter go out of the list. Other person get an opportunity, the matter be listed.
Your Lordship, kindly give a last chance, Your
What
Lordship.
last chance? December you have taken time, 22nd January taken time, you are not taking, let the matter go out of the list when you are.
Your Lordship, kindly give a last chance, Your Lordship.
What last chance? What you will do?
So we are trying, but we have
What
not
you are
get the
trying?
death certificate.
What certificate?
2 attesting witnesses have died, Your Lordship.
Have you issued the safina? Have you passed have you prayed for an order before this court for issuance of safina upon the witnesses? Or have you made a publication? Who is your senior?
Ritik Chaudhary, Your Lordship.
Then, as per the prayer made by the counsel for the petition, the case is adjourned for 2 weeks. Let the matter appear on 18th of March 2025. It is made clear that on the date fixed, if the petitioner will not take appropriate steps, appropriate order will be passed.
Grateful, Your Lordship.
None appears on behalf of the petitioner. No accommodation is sought for. Let the matter go out of the list. Next.
Lord 137, I appear for the petitioner, my lord. In the last occasion, your lordship had, my lord, directed to complete all the defects. My lord, that has been done, my lord. But when I had been there to the department, my lord, this was indicated that leave of court is required to be obtained to file this. As much as, my lord, this notarial certificate, the notarial certificate, my lord, is not there.
Notarial certificate of what?
Of the attesting witness affidavit. Your lordship would kindly consider, I had inquired, my lord, in Bombay. My lord, the regular notary is done without the certificate. If your lordship is kind enough to, my lord, grant me leave, the attesting witness, the affidavit has been notarized. And my lord, over here in the department of your lordship, my lord, the certificate is required. The notarial certificate is required for the department. My lord, I have been informed by the department that in the event my lord is kind enough to grant me leave, my lord, this can be taken on record.
Notary Act hai. नोटरी एक्ट है यहाँ पे? Sir, under the Notary Act,
My lord,
the seal, there are three types of the seal.
my lord.
One is affirmation, one is the executant, and another is something else. So if it is affidavit, it will go as an affirmation. If the affirmation is then affirmation, there is a seal. This read over and explained to the.
Yes, that is there.
That.
My lord, your lordship will kindly turn the page, my lord. The red seal is.
My
lord.
Where is that? Read over and explained to Hindi, and after knowing the contents, it was signed.
No, it is not a matter of Hindi, my lord. The
Hindi, English, Bangla, whatever it may be, there will be a blank. There will be a seal. The contents of so and so of the affidavit read over to the petitioner blank. Either Hindi, English, Bangla, Telugu, Tamil, Bangla, whatever it may be. That has to be filled up by the end by this notary number, and all this thing is there.
Is there,
okay.
my lord.
Book
If
number
your lordship
so
will
and so,
kindly
page
take
number
the
so and
other
so,
one also, there are two documents. The notary book number and other thing are there. The only difficulty, my lord, is the department of this honorable court, my lord. In the usual.
That's why I'm telling. That is the certificate.
Yes.
That is the certificate, because there is a seal. In the seal, it has to be certified, read over and explained, and after knowing the content, the executant or the person has affirmed the
My lord,
affidavit.
in my respectful submission, my lord, in Bombay, my lord, I have checked, my lord, that this
That's
is
why I
the usual
wanted to see the Notary Act, because Notary Act is a central act.
central act. I bow down to your lordship, my lord.
Then you have to produce whether the state has changed, amended that. If the central act, I think this round seal is the common one.
Is the common one.
And this this number seal is common one.
My lord.
With regard to before me is okay, but there was another seal.
My lord, my lord, if the red emblem, your lordship would kindly. This is the usual. If your lordship says
This is the central government notary. State government notary emblem will not be there.
My lord, your lordship is well versed in the subject, my lord. This is, my lord, what I could obtain, my lord. If your lordship kindly grants me leave
Who is he? Attesting witness.
Attesting witness. Attesting witness.
And even though, kindly see the first page, put the seal here.
My lord.
It is to be here, so that nothing can be incorporated. So suffering for the petitioners, counsel for the petitioner submit that he has obtained the attesting witness he has obtained the attesting witness has affirmed the affidavit before the notary public at Mumbai, and as such he prays leave to file the same in the department.
My lord.
In view of the submission made by the counsel for the petitioner, the leave is granted to the petitioner to file the affidavit and the declaration of the attesting witness, which was affirmed before the notary public in the department within a week from date.
My lord, I am deeply obliged.
Next. Yes.
Lordship, this matter will probably come back to my lord. It is that probate application which was inadvertently tagged with several part-heard matters that were being heard by my lord Justice Arindam Mukherjee. My lord had produced the order file on the last occasion and noticed that the matter was appearing long back, and my lord had fallen from my lord that I was to mention the matter before my lord Justice Mukherjee. My lord, I have done so. My lord, apparently several matters by that order, several matters which were not supposedly to be part-heard were tagged. My lord Justice Mukherjee was aware. What fell from my lord Justice Mukherjee is that he has already instructed the testamentary department and necessary detagging will be done. Moreover, my lord, the main matters which were part-heard were also disposed of. Also, my lord, a similarly part-heard tagged matter incorrectly is appearing before my lord today as item 132, and probate has already been granted. My lord, it is PLA 96. My lord has, what fell from my lord Justice Mukherjee was that I was free to pursue my application before my lord. There is no impediment. My lord, there is no live streaming before my lord Justice Mukherjee's court, or else I would have produced that. But my lord, I have.
Why you're not getting the one page, one line order?
My lord, since the main matter, the main
See,
part-heard matters already disposed
that
of.
is not the. It is with regard to our decorum.
Yes. No, my lord, I have made specific mention of this. That is, my lord Justice Mukherjee, please to pass a one-line order. My lord specifically said all matters, even the main matters which were actually part-heard before my lord, have already been disposed of.
I am on the same boat.
Yes.
I am on the same boat. Only one matter has been disposed of.
Yes.
Out of the entire list of about 12 matters, one matter has been disposed of. Nothing has been listed. For 1 year, we are suffering, my lord.
And my lord, this is not the question before my lord Justice Mukherjee in the part-heard matter was on 283 subsection 3, my lord. Nothing of that pertains to my probate application.
283, that 25th January, that matter was allowed.
Yes, my lord. So, my lord Justice Mukherjee, this has specifically fallen from my lord. I am humbly beseeching, there will be no breach of decorum on my lord's part if my lord proceeds.
No, but the order reflects your case number.
My lord, PLA 96 of 2021 also same.
You do one thing.
Yes,
मानुतोष एक काम करो ये वाला मैटर को ना देखिए ऑफिस के साथ मेरे को भेजो.
But the order, my lord, which is passed. In
Okay,
about
let me
19th
take
January.
the clarification from the department.
My lord, my lord.
That will be listed.
Only my lord notices this much. I am grateful to my learned senior friend.
No problem.
Only my lord notices this much. PLA 96 of 2021 was similarly tagged as a part-heard matter by that same order. But my lord not only is in season of that matter, my lord has passed a substantive order.
No, that has not been brought to this.
Yes, my lord. Possibly it was not brought
Not
to
brought
my
to
lord's
this court.
attention.
Yes. Come tomorrow, I will see.
My lord, I am deeply
Only
obliged.
PLA 115 of 23, the order was passed.
Yes,
That is the
115.
25th of January.
Yes, my lord, 25th of January.
25th of January.
16th of January.
Huh?
16th January.
16 January. 16 January.
16th January. Only on one matter, my lord, that order was passed.
Probate Chandra Sen to bolchen, sir. 115.
In the court
Okay,
of yes.
okay, let's come tomorrow. We'll see to that.
I am obliged, my lord.
Yes. Not today, huh?
My
One.
My lord, this is my application for grant of probate of the last registered will dated 15th of January 2020 of the deceased testator, namely Sham Sundar Dalmia, who died on 20th of February 2023. The will is Annexure B. The death certificate is Annexure A. If your lordship looks at the will, there are two attesting witnesses named
Will Sham Sundar Dalmia.
Yes, he's the testator.
Just a minute.
Then in the will, your lordship will find there are two attesting witnesses named Kamal Singh Chhajar and Santosh Choraria. They have used an affidavit, which is Annexure C. Both of them have filed an affidavit. Then your lordship will
What's
find
the name of the executor?
the name of the executor is Mr. Pansari. I'll just find out his name, my lord.
Rajendra Prasad Pansari.
Rajendra Prasad Pansari.
Where is
That is internal page number 4 of the will, paragraph 3. I appoint Mr. Rajendra Prasad
Absence,
Pansari.
Sachin Kumar. In his absence, okay.
Yes.
And two attesting witnesses.
So Rajendra Prasad Pansari is before your lordship today. And paragraph 4 of my petition, I have named all the natural heirs. There's wife, who's the widow, son, and two daughters. They have all given no objection to the grant of probate, which is Annexure D collectively.
Then he died.
He died on 20th of February 2023. The certificate of the death certificate is Annexure A.
Yes. Both
Now, my lord,
witnesses have given
yes,
affidavit.
both of them have used an affidavit, which is Annexure C collectively. Then all the natural heirs have given their no objection to the grant, which is Annexure D. Then one of the properties, which was situated in Mathura, pursuant to the order of this honorable court, my lord, under section 283(3), as your lordship is aware, there was a direction for making publication, paper publication, and also fixation in the court premises. The report had come forth. Then there was a certain timeline mentioned, post which the matter was to be listed. After the matter was listed, the no caveat certificate was missing. So on the last occasion, your lordship had directed the department to look into the matters and to pass if there is no caveat. So that certificate, I'm told, has been now furnished by the department.
Yes.
So may the grant of probate be, my prayer A be allowed. My lord, I'm also seeking one indulgence before your lordship. I don't know whether it is permitted by this court or not. If it could be done without drawing up of the order, my lord.
It is under the law, it is under the.
My lord, I'm told, yes, that probably your lordship will require, I'll have to pray for a leave before your lordship.
That is
Yes, if your lordship will be kind enough to
concerns
grant me
occurring to
that.
the petitioner. The petitioner has filed the present application for grant of probate of the last will and testament of the testator Shyam Sundar Dalmia, dated
15th of January 2020, registered on 16th January.
dated 15th of January 2020, which was registered on
16th January.
16th of January 2020. Twenty. 15 January, seen?
Oh, yes, 15th of January.
It
Yes.
was registered on the
15th of
same
January.
day. Registered on the same day. Counsel for the petitioner submitted the testator has executed his last will and testament in presence of two attesting witnesses while possessing good health and fit state of mind. Full stop. The testator died on
20th of
20
February.
February 2023, leaving behind 4 legal heirs, that is wife, a son, and 2 daughters. All the legal heirs have filed their affidavit of consent stating that they have no objection for grant of probate to the petitioner of the last will and testament of the testator dated 15 January 2020. Full stop. 2 of the attesting witnesses have filed their affidavit stating that the testator has executed his last will and testament in their presence while possessing good health and fit state of mind by appointing the petitioner as sole executor of his last will and testament. Full stop. Counsel for the petitioner further brought to the notice of this court that one of the property is situated at Mathura district, state of Uttar Pradesh, outside the jurisdiction of the state of West Bengal, and accordingly citations were issued under section 283 within bracket 3 of the Indian Succession Act, but none has come forward to raise any objection, and the department has submitted no caveat certificate. Heard the learned counsel for the petitioner perused the original will, death certificate of the testator, affidavit of consent of all the legal heirs, affidavit of attesting witnesses, and the no caveat certificate. This could find that all the legal heirs in their affidavit have categorically stated that they have no objection for grant of probate of the last will and testament of the testator to the petitioner. The attesting witnesses in their affidavit have categorically stated that the testator has executed his last will and testament in their presence while possessing good health and fit state of mind by appointing the petitioner as sole executor of his last will. And not sole as executor of his last will. Considering the above, this court finds that the petitioner has proved the will and is entitled to get the probate. The department is directed to issue the probate of the last will and testament dated 15 January 2000 on compliance of all formalities. At the time of grant of probate, the copy of the will be made part of the probate. So the department is directed not to complete and draw the orders. PLA number is disposed.
Grateful to Raj.
Next. None appears on behalf of the petitioner. No recommendation is sought for. It is fine from the record the matter was listed on 6th of January 2025. On the said date also none appears on behalf of the petitioner. According case was adjourned. Today also none appears on behalf of the petitioner. This court find that the petitioner is not interested to proceed with the matter. Accordingly, PLA 222 of 2023 is dismissed for default. Next.
May it please, my lord, this is my application, my lord, for grant of a probate, for grant of probate of a will dated, my lord, 6th of October 2010, my lord. My lord, examination of one of the executors, my lord, was ongoing, my lord. In the meantime, over the course of the examination, my lord, it transpired that the original will was lost, my lord, and the fact that a GD had been lodged, my lord, in respect of that will needed to be brought on record, my lord. We had filed an application, my lord, by an order dated 6th of January, my lord. That application for amendment has been allowed, my lord. My lord kindly keeps a date, my lord, for that the remainder of the examination of the executor, my lord, may be held, my lord.
You want to examine the
Harshvardhan Lodha, my lord.
solemn form.
My lord, the examination has already been held in part, my lord. Only few questions, my lord, left. Any day, my lord, after tomorrow, my lord, because the
So-and-so appearing for the petitioner. Will the counsel for the petitioner submit that examination in part of the petitioner witness was carried out, but it was deferred accordingly. But it was deferred accordingly. The petitioner intend to examine the witness and conclude the evidence of the petitioner witness on the next date fixed. In view of the submission made by the counsel for the petitioner, let the matter appear on 11th March.
Very well.
11th
Very
March at 1 p.m. At 11th March for examination of no ये उसका है ना फर्स्ट डे आएगा ना ये तो नॉन कंटेस्टेड है
non-contested.
11th March.
Very grateful, my lord.
That my application for grant of letters of administration, Mala, the applicant before your lordship is Mala, the husband of the deceased,
What
and
is
Mala,
the
they are
GA?
Mala, the letters of administration, Mala.
GA?
Mala, amendment application, I'm told that's disposed of, related to locker.
GA3 is disposed of.
Disposed of. Now, Mala, kindly takes the Mala, the application, main application. Mala, it's for Mala, grant of letters of administration. Mala, kindly come to page 2, paragraph 4.
Letters of administration.
Yes.
So what is the GA? What the amendment? What is the GA3? What amendment was allowed?
Locker was included, Miller. One locker was included.
Yes.
Miller, kindly takes page 2, paragraph 4. Miller, first applicant, Miller, first name, Miller of the legal heirs.
Who is the petitioner?
Miller, the first one, the husband.
Husband.
And Miller, both Miller, the married daughter and Miller, the son has given Miller their affidavit of consents. Miller, those are also there. Miller, properties both within and outside, Miller.
Within and outside.
Outside of this court's jurisdiction.
Where is the affidavit?
Yes, Miller, kindly take the affidavit of assets. Miller, one locker is at Miller, kindly takes page 2.
Affidavit of assets.
Yes. Kindly takes page 2.
Yeah, affidavit of assets can they go?
Annex করা নেই আলাদা আছে
Okay. Page 2.
Page 2.
Yes.
Miller, the first one is Miller, an account, savings account,
Correct.
which is Miller within.
No, it's correct. Where is what is the total amount? 4 crore.
Yes, total amount
4
is Miller
17
3 crores. Yes.
4 crore after the amendment.
Yes.
4 crore 17 lakh 98,796.
Yes. Yes.
That is the total.
That is the total. Miller,
where is the death certificate?
Miller, yes, death certificate is annexed. Miller, to my application.
15 December.
Yes, kindly comes to Miller, page 9. Now, Miller,
yes.
Only one Miller, the ritual has been Miller to put Miller, give a bond for granting of, I don't know Miller, Miller is following that or not. But Miller, there is a ritual of Miller giving Miller a bond by the Miller, the applicant, which is Miller apropos or Miller in consonance with the Miller, the amount. Yes. No, Miller, there Miller, our court used to follow. If Miller doesn't give,
yes, where is that?
Miller, no, I am Miller, no, Miller, I am harping on your Lord, Miller, before Lordship that Miller, that ritual has now being Miller not being followed by the division bench. Miller, in one of our matters, Miller, amount around 90 lakhs was directed to be paid for a bond. Now, Miller, we had preferred an appeal. Miller, this was the division bench order. This Miller keeping Miller abreast of the Miller, where Miller. Let's sureties, Miller, the division bench has reduced it to only Miller the undertaking.
No, in one of my judgment, this court has held that it is the deceased died. Correct. And you being the legal years applying for the administration.
Yes.
So why you should be burdened?
Then Miller kindly
my judgment is there, but I could not. No,
no, Miller,
my judgment.
I will look into that. Miller, I have also one Miller coordinate with Justice Patnaik's judgment, Miller, following this judgment. And he has also held that Miller waiving only Miller sureties Miller has been held in this. I am not Miller showing that to your lordship. He has relied on this judgment.
Because Mr. Jishnu Chaudhary, Jishnu Chaudhary has argued the matter.
I will inquire it.
And I had passed an order holding that, and
that seems to be in my favor.
Yes. And I follow the judgment of Delhi High Court Justice Bela Trivedi.
I am giving one more handle to your lordship, division bench of our court.
No, here it is correct, but there the allobity has been given. Why it is not necessary?
Yes. No point, because it's not an outsider.
Now I find in here only in this jurisdiction I find with regard to the bond.
Mostly
what has happened? Actual what has happened? It is only indemnity.
Yes.
It is only indemnity if the court has granted the letters of administration to you. If suppose letters of administration or succession, whatever it is.
I don't follow my duty.
Only to follow. So in future, if anybody come, so who will take the responsibility? Only the indemnity, either one surety or two surety of like amount. Only they will come with any of the or property valuation or any of the valuation. He give the valuation certificate and then they will give the indemnity. Yes, I will take care of it. That is only indemnity. But I find here, when I inquire from the department,
the amount has to be secured.
To be secure. That I don't know.
This has been introduced very lately, last year prior to that, or there 2 years back.
No, when I joined prior to that, it was there.
It was there.
When my determination prior to that, it was
yes, it was there. I'm saying, Millard, it was 2 years back.
Concern suffering for the petitioner.
And we are ready to give the undertaking.
Petitioner has filed the present application for grant of letters of administration in respect of the estate of the deceased Nisha Banka. Nisha Banka, full stop. The counsel for the petitioner submit that the deceased died on
15 December 2020.
15th of December 2020, leaving behind her husband Shashank Banka, married daughter Diksha Goyal, and one son Rishabh Banka. The petition before this court is this husband of the deceased. Police. Both the legal heirs have filed their affidavit of consent stating that they have no objection for grant of letters of administration of the estate of the deceased Nisha Banka to the petitioner. Consider the submission made by the counsel for the petitioner. Peruse the affidavit of consent of the legal heirs. Full stop. Prayer A. Now, consider the submission made by the counsel for the petitioner. Peruse the
Millard, prayer A, Millard.
Then the natural difficulty.
Yes, because why, Millard? When this was filed, it was
the
before
department
the
is
earlier
directed
court.
to issue letters of administration in respect of the estate of the deceased Nishi Banka with effect throughout the Union of India of furnishing personal security of rupees.
Millard, I was Millard praying Millard in the like nature Millard view the division bench. Millard, I will provide the Millard the undertaking if you do the undertaking. It's the same issue that has come up.
By furnishing a personal bond executed by the petitioner in the form of undertaking to reimburse the estate of the extent of rupees 4 crore.
Yes, কত বল?
4 crore 17. 4 crore 4,17,98,796.64 in case of any loss to the state caused by caused by the petitioner without the necessity of security to back it, that is the cash fixed deposit,
Yes, cash fixed deposit,
etc. The census ELA number disposed of.
let the order, Milad, there is no necessity of drawing up and completion of the
The
order.
department is directed to not to draw and complete the order.
Obliged. Is it, my lord, pressure to grant, Milad, fix a time limit within which, Milad, very.
Yes.
Well, I'm appearing on behalf of the executor, my lord.
I have already filed my affidavit in support of the caveat matter.
My lord, my respectful submission is that.
Yes, let the one person complete. Yes.
I have already served a copy of the
What? Affidavit?
in support of the caveat matter.
Yes.
My lord, kindly appreciate that the petitioner was served with the special citation and he has come out of town now. And now, my lord, he has not preferred any appropriate application, filing a GA. That has not been done. Only a affidavit in support of caveat has been filed. To my respectful
That is
submission,
your application.
that is not the proper
Can you
application.
see the 15 January order?
In terms of the order,
It was direction to take
caveat
appropriate
pays for
steps.
time for taking steps.
yes, my lord, I have filed my Bhakalatnama caveat as well as
No.
Caveat, how the caveat can be accepted by this court?
Yes, my lord, that is my only submission.
After the lapse of 8 days.
That is my only submission.
Cannot.
I have filed a department I accepted.
Huh?
In terms of the order, my lord, I have filed my lord.
Court has only given a taking appropriate steps.
That is not the appropriate step, no, only my submission.
My humble submission is, my lord, this is, I have,
What do you want now?
I have already filed my affidavit, my lord.
So and so appearing for the petitioner. So and so
Let the
appearing for the
caveat be discussed,
caveator. Police caveator and counsel for the caveator submit that the caveator has filed the caveat in support of affidavit of caveat in support of caveat. Counsel for the petitioner submit that he has received the affidavit in support of caveat, but the petitioner has filed the affidavit in support of caveat much later than the law prescribed. Full stop. In view of the above, the full stop. This court finds that the petitioner, without paying for any leave or without any application, the caveat has been filed. Accordingly, the caveat is not accepted till now.
No,
What leave? Leave on the last occasion granted.
Granted, madam.
You are not understanding the English. What can be done?
I am the only son, madam.
So what can be done?
This application is not maintainable at all, madam.
Sir, you have to come by making a submission will not do. You have to come with some prayer.
In support of my affidavit,
There are some procedure. How the caveat is to be filed. How if the delay is there, how the caveat is to be filed.
in terms of the order, madam, I have filed my.
This court has directed to take appropriate steps. Court has not stated that file the caveat.
Absolutely.
What you have stated that on the prayer, you may be given time to take appropriate steps. What is the steps?
My understanding.
Okay. क्या बोला? Date. Let the matter appear on 12th March 2025.
My lord, yesterday, I had shown your lordships, my lord, that similar reliefs had been sought, my lord, before, my lord, the division bench.
Yes.
Now, my lord, I just have given production, my lord, of my lord GA3. My lord, kindly allow us, my lord, to apply. My lord, we've applied for certified copies, but my lord, they have said, my lord, that because the
Send to the
records are
court.
here, my lord, they can't give it to us. My learned friends, of course, have a copy already because, my lord, this was filed by their client. Now, my lord, kindly have a look at GA3, my lord.
Yes.
My lord, paragraph 65. Now, my lord, kindly note one thing. If I'm not mistaken, my lord, it should have been filed on 12th November 2020.
17 November.
Yes, so my lord, 17th November. Kindly, my lord, this is before the 16th April 2021 resolution. So, my lord, this is filed on 17th November. Affirmed on the 12th, my lord, I hope.
Yes.
Now, my lord, kindly have a look at page 33, para 65.
Yes.
My lord, kindly see, my lord, after 1st October 2022 order, that is, my lord, the division bench, which had that clarify and abide by, my lord, the said two members of the APL committee as well as the defendants are deliberately distorting and misconstruing the order subsisting in the following manner. My lord, kindly come to E. To the extent the defendants are contending that the plaintiff number 1 cannot function as trustee or committee member of societies, even though they are no shareholders of such entities, and the estate of PDB has no right whatsoever in such trusts and societies. So, my lord, this is one. Now, my lord, kindly come to para 66. The petitioners rely upon and annex hereto the following emails, letters, communications, orders of Justice Mohit Shah, retired, and E.C. Chakraborty. My lord, kindly see 8th October. My lord is one of them. 8th of October.
Yes.
Lordship has that, my lord.
Yes.
A meeting of APL committee held through video conferencing. The two joint APLs decided to write letters to the companies, trusts, and societies of MP Bulla Group for communicating judgment dated so-and-so, and write letters to the secretary. My lord, we are not concerned companies. My lord, this is the letter referred to, my lord, in the circular resolution of 16th of April. Now, my lord, kindly come to, my lord, kindly come to page 36, my lord, bottom, 15th October 2020. My lord, kindly see, my lord, on the right-hand side column, compliance has been sought of the judgment and order dated so-and-so September, and order of division bench dated inter alia contending that the estate of PDB holds a controlling interest in shares in so-and-so, and also the controlling interest in trusts and societies in MP Birla Group, annexing charts with so-and-so. Now, my lord, kindly come to 38, 22nd October 2020.
Yes.
This is, my lord, important. This letter sent to trustees, managing committees of 8 societies. My lord, kindly see, my lord, these are, my lord, the societies, my lord, which are, my lord, mentioned here. Hindustan Medical, Shreyas, Eastern India, MP Birla Foundation, Bellevue Clinic, South Point Foundation, and so and so. And, my lord, APL has the controlling interest, and that members are drawing a plan for ensuring smooth operation. And, my lord, lastly, my lord, kindly come, my lord, to, my lord, para 71, 68, my lord, 68 first. Petitioner here to also annex here to similar emails, letters, communications from defendants and other advocates. My lord, 21st September, kindly note, Khaitan and Company letter, my lord, which is, my lord, referred to.
Dated?
My lord, 21st September 2020. First one, my lord, Khaitan Company letter, seeking compliance of, my lord, order of 18th September. That's, my lord, 21st September. Then, my lord, 6th of October 2020, 28th October, my lord, Khaitan Company again, and my lord, 2nd November 2020 to chairman, trustees, etc. of Bombay Hospital. Then, my lord, 2nd November, different section. Kindly see, this is the important one. To different societies, namely South Point Education Society. This is the letter, my lord, which is referred to, my lord, in my lord, 16th April. That there is restraint from holding to act in complete conformity, etc. Then, my lord, again, my lord, these are, my lord, letters, my lord, which have been written, but they are primarily, my lord, regarding companies. This is, my lord, what has now kindly come to para 71. Purported decision taken at APL committee meeting held on 8th by 2 members and the acts of interference summarized above are bad for the following reasons. Now, my lord, all the reasons which they have argued here, my lord, is given. Then kindly come to para 76. The petitioner therefore humbly prays for appropriate orders on the defendants and APL committee members, restraining them from interfering with plaintiff number 1's functioning as director of companies, trustee of trusts, and committee members of societies and the like by issuance of letters more fully summarized in 66, 68 or in other similar directions, so and so. And kindly see the prayers. Decision of 2, page 58, my lord. Decision of 2 members of APL committee dated 8th October and other similar decisions be set aside. Then, my lord, injunction restraining APL committee from giving any effect to decisions of 2 APL committee members dated 8th October. Then, my lord, paragraph 66 and 68 are challenged. Prayers, my lord, D and E.
Yes.
My lord, this is, my lord, the, my lord, prayers, my lord, which are made. Now, my lord, what is important is, this is GA3.
Yes.
Now, my lord, GA4, my lord, kindly have a look. GA4, my lord. My lord, I don't know when it was filed, but my lord, I think affirmation is 22nd March. Lordship kindly notes, my lord, the date of filing. Lordship has the date of filing, my lord, of GA4.
GA4, 19th April 21.
Now, my lord, this is, my lord, important because, my lord, it's affirmed on 22nd March. My lord, filed on 19th April 21.
Yes.
So, my lord, this is after the circular resolution. Now, kindly note this, my lord, paragraph 12I.
22nd March, yes.
Yes. My lord, kindly see, my lord, page 15.
Page 15.
My lord, page 15, para 12.
Yes.
Subsequent to filing of the appeal being APO 92 of 2020 and the application for stay being GA so-and-so and passing of order dated so-and-so, that's, my lord, both the orders, my lord, 1st October as well as the 2 joint APL so-and-so being nominee have acted contrary to law by taking advantage and of misconstruing the impugned judgment and order dated as clarified by in the following manner. My lord, kindly see the manner. The said 2 joint APLs, in spite of being aware that the Honorable First Court by the judgment and order as category L has no jurisdiction to pass any order against, issued letters on the letterhead of administrators to board of directors of various companies and the trustees managing of various trusts, intimating them about the judgment and the order and seeking compliance of so-and-so, etc. The decision to issue the said letters to various entities at an internal meeting of 8th October without giving any so-and-so opportunity of hearing has challenged the said by way of an application GA3 which I placed. The letters were also made available to the petitioner by P.S. Nair, Secretary to the APL committee under cover of letter dated so-and-so. Now, my lord, kindly come to page 19. Para 13.
Yes.
Similar emails, letters, communications that were also sent by defendants to various companies, trusts and societies, details whereof are stated as under. At page 21, my lord, kindly come to similar emails were issued to key managerial personnel of so-and-so and other companies, chairman, trustees and other members of so-and-so South Point Education Society, Sevanidhi, etc., etc., etc. My lord, goes down. Copies of one such letter addressed is annexure S. My lord, which is at page, my lord, it's low down, my lord, I don't know. It's similar, my lord, to the letters which were given, my lord, to me. And then, my lord, kindly see, my lord, para 35. At page 35, the petitioner has also filed a separate application being GA so-and-so, essentially challenging the decision of so-and-so to write to all the company society. That was GA3, which decision was to communicate orders to all and ask them to give advance notice of their internal meetings, and also challenge the right to issue directions to act or not to act in a particular, as well as notices of contempt given by so-and-so, etc. The prayers made in GA3 are set out below, which I had placed, my lord. And then, my lord, kindly come to, my lord, 37. GA 2 and 3 along with appeals were listed on 27th before the Honorable Division Bench. On that date, the Honorable Division Bench intended to hear out and dispose of the appeal and fixed all appeals for hearing on 6th. In fact, the Honorable Division had made it clear that appeals would also be heard thereafter on 7th and thereafter on regular dates. Then, my lord, para 38. In order to expedite the matter and to avoid further delay, petitioner deemed it fit not to separately move so-and-so and ask for separate so-and-so. So, my lord, then, my lord, they decided not to move 3. Then kindly come to, my lord, paragraph, my lord, 41. In the meantime, subsequent developments have also taken place, which necessitates making of the present application for further orders in addition to prayer for grant of interim reliefs already prayed for in GA 2 and 3. Stated earlier, did not pray for interim orders so as not to delay hearing of appeals which were fixed. However, since that could not happen, petitioner, in addition to the prayers now made in view of sub, is also praying for interim order so-and-so. Then, my lord, the acts and conduct since so-and-so not in accordance with law by the said, treating judgment and order dated and order of division bench as a decision which leads to automatic cessation, and B, my lord, petitioner has not appointed, reappointed as director of so-and-so. So, my lord, now, my lord, they say 2 and 3 was not pressed because they expected appeal to be taken up. Yes. Appeal, my lord, could not be taken up or concluded. So, my lord, now, my lord, and subsequent developments, so they are filing again. Now, my lord, GA4. Now, kindly come to, my lord, paragraph 52E at page 56.
Yes.
My lord, 52 starts at page 56. The aforesaid decisions of APL summarized in pre are illegal for the following, amongst other reasons. Nomination of trustees of trusts and societies in respect to has no right in an action which is again completely illegal and not in any manner in terms of the respective constitution documents of these trusts and societies or any law. The petitioners crave leave to refer to memorandum, rules, etc. Now, my lord, with the greatest of respect, I have, without referring to division bench, showed, my lord, what they have done is wrong. Correct. Now, my lord, here they say everything has been done because of the misinterpretation of division bench. And, my lord, they specifically take the point. The decision to nominate trustees and all acts which have no nexus with functioning, no reasons have been given why appointment of trustees is at all within the scope of so-and-so. Now, my lord, kindly come to para 54. My lord, at page, my lord, 60.
Yes.
The petitioner was shocked and surprised to learn from his wife Anamika Lodha of notices dated 4th March 2021 issued by so-and-so, etc. of the following persons stated hereunder: Eastern Education, etc. My lord, these Hindustan Medical Institution, my lord, your lordships, my lord, would recall, my lord, one of the matters, my lord, is, my lord, before your lordships. These are, my lord, referred to. Then, my lord, these are at, my lord, page 63. My lord, kindly see, my lord, paragraph 57 states that decision of the said two APLs dated so-and-so, so-and-so, so-and-so go to show that they are taking a full advantage of non-grant of stay of the order dated, and this is being used as a ploy to get around the express words of so-and-so. Then, my lord, paragraph 62 at page 65. The said actions are being taken by the said two joint APLs in hot haste to render the appeal pending before the infructures and nugatory. Action in any event is illegal, null and void. Same is contrary to various judgments, etc. And contrary to unanimous inventory report filed from so-and-so, was the third member. From letters, it is apparent that the said have deliberately misconstruing the judgment so-and-so and have been misrepresenting various entities, that such entities come under scope and so-and-so. Annexed here to and marked with letter TT is the full list of which do not have a, and where the petitioner is a trustee or managing committee member. Now kindly have a look at, my lord, annexure TT. My lord, it's, my lord, volume 9, my lord, of, my lord, GA4. One 1036, my lord. 1306. My lord, South Point is mentioned there.
1036.
1306, my lord. 1306, item 7. TT, my lord, has.
Yes. South Point Education Society.
Yes. Now kindly have a look at the reliefs, my lord. Prayer, my lord, is at page 66.
Restraining joint APL.
APLs from in any manner interfering with discharging of petitioners' functions and duties as trustees and of managing committee, member of societies and trusts, particulars whereof are given in annexure TT. Now, my lord. So, my lord, specific, my lord, injunctions, my lord, sought here. Then, my lord, GA5 is filed.
So what has happened to this?
My lord, I showed your lordship yesterday, no orders. All these were prayed for. No orders were granted by the division bench and could not have, my lord, because division bench is saying societies are not before us. And in any event, my lord, South Point was never before. Shreyas Medical was, and my lord, it was detagged. I showed your lordship, my lord, that order. Yes, now kindly have a look at, my lord, GA5. My lord, this must be, my lord, well after, my lord, 16th April.
June 21.
June 21. Kindly have a look at, my lord. The prayers, same complaints, my lord.
22nd of April.
Yes. Page 13, my lord.
Yes, good.
Injunction restraining from issuing any direction or exercising any right not recorded in this shares. And my lord, B, stay of the order dated 18 September and the direction which restrains petitioner from holding any office in any of the entities of MPB. My lord, the clarification as submission was related to companies. My lord, on that basis, my lord, the trusts have proceeded, societies have proceeded, APL has also proceeded. And when that happened, no complaint. No complaint, my lord, of contempt. Instead, my lord, they say there is a doubt. So you please now stay expressly the order dated which had been refused.
Yes.
Now, my lord, this being the position, my lord, my first respectful submission before your lordship is, my lord, in any view of the matter, my lord, just give me one moment. My lord, in any view of the matter, my lord, what I had submitted before your lordship is, my lord, removal, my lord, is an independent resolution. It's a resolution by itself. So what happens to the orders, my lord, is only immaterial. Second, my lord, in any event, my lord, the orders themselves, my lord, are and not, my lord, cannot be binding, my lord, on, my lord, the societies which were admittedly not parties. Correct. And, my lord, the specific finding of the division benches that they cannot give any direction, my lord, to, my lord, the societies. Now, my lord, if that is the case, there has to be an independent challenge. Second question, my lord, which I answered yesterday, my lord, was there a violation of, my lord, the order of September 2020 and, my lord, October 2020? And my respectful submission was no. There is no violation of that order. Even if it was held to apply, my lord, to societies. Yes. No violation of the order.
Yes.
And, my lord, the order of, my lord, the division bench of 14th of December 2023, my lord, clearly shows, my lord, that the reliefs which they are asking for here, which they had asked for there, yes, my lord, was refused, was not granted. Yes. And thereafter, my lord, they've chosen, my lord, not to challenge, my lord, the resolution of 16th of April 2021. They say it's in violation of order. Order has gone, so state law is declared, so I come back. My lord, with the greatest of respect, my lord, that is not the case. In any event, my lord, now kindly, my lord, take 3 of the cases, my lord, which they cited. My lord, one is, my lord, of 2008, 14 Supreme Court cases.
Give the note.
My lord, this is, my lord, Assistant Commissioner Income Tax Rajkot versus Saurashtra Kutch Stock Exchange Limited.
2008.
2008, 14 Supreme Court cases, 171. Have a copy.
Yes.
Now, my lord, the most important thing is my copy. So, the side by side keep report. I want to do it side by side. My lord, the most important thing is, my lord, here, my lord, we were really concerned, my lord, with the expression, my lord, really, my lord, whether there was a mistake apparent on the record, my lord, that expression as appearing in section 254(2), my lord, of the Income Tax Act. My lord, I'll very briefly, my lord, give, my lord, the position. My lord, my lord, appellate authority, the appellate tribunal here, my lord, when, my lord, holding in favor, my lord, of, my lord, the one of the parties before it, my lord, did not take notice of a judgment of the Jurisdictional High Court, which was the Gujarat High Court. My lord, so, my lord, an application was made by the assessee saying, look, the very fact that you have not taken note of the judgment of the Jurisdictional High Court on this issue is an mistake apparent from the record. My lord, the question arose, is it a mistake apparent from the record or it has to be challenged separately? This was the issue. And, my lord, the Supreme Court held, my lord, that, my lord, it is a mistake, my lord, apparent from the record, because, my lord, the Jurisdictional High Court had declared the law, and that, and, my lord, any order, my lord, had to comply with that law. Correct. The fact that, my lord, that law was not noticed, that law was not noticed, my lord, there was a mistake, my lord, which was on the record. Now, my lord, kindly have a look at, my lord, my learned friends relied on paras 35 and 38. Now, my lord, kindly have a look at, my lord, paragraph 1. The present appeal is directed against the judgment and order passed by the High Court of Gujarat, Ahmedabad on 31st March so-and-so. By the said judgment, the High Court confirmed the order passed by the Income Tax Appellate Tribunal, Ahmedabad in miscellaneous so-and-so. By the said order, Arbitral Tribunal held there was a mistake apparent from the record within the meaning of subsection 2 of section 254, and accordingly it recalled its earlier order passed on 27th. So, my lord, tribunal said, yes, I admit, we didn't take note of it. We are recalling it in exercise of our powers under 254(2). Now, kindly come to para 9. My lord, 7 lines from the start. The power under section 254(2) can be exercised in case of any mistake apparent from the record. According to counsel, even if the order passed by the tribunal was incorrect or wrong in law, it would not fall within the connotation mistake apparent on record. If the assessee was aggrieved by the said order, it could have challenged the order by taking appropriate proceeding. Miscellaneous application was not maintained. This was the objection, my lord, in, my lord, the appeal. Now, kindly come to, my lord, paragraph, my lord, 17. Having heard learned counsel for the parties, 2 questions have been raised by the parties before us. Firstly, whether the Income Tax Appellate Tribunal Gujarat was right in exercising power under subsection 2 of section 254 on the ground that there was a mistake apparent from the record committed by the tribunal while deciding the appeal, and whether it could have recalled the earlier order on that ground. Secondly, whether on merits the assessee is entitled to exemption as claimed. Now, my lord, kindly take para 20, bottom of the same page. My lord, the section is set out. Kindly see 254(2). The appellate tribunal may at any time, within 4 years from date of order, with a view to rectifying any mistake apparent from the record, amend any order passed by it on subsection and shall make such amendment if the mistake is brought to its notice by the assessee or the assessing officer. Now, my lord, kindly come to para 23. There is, however, no dispute by and between the parties that if there is a mistake apparent from the record and the assessee brings it to the notice, he must exercise power on so and so. Whereas the learned counsel for revenue submitted that in the guise of exercise of power under so and so, really the tribunal exercised the power of review not conferred on it by the act. Counsel for assessee urged that the power exercise was of rectification of mistake apparent, which was strictly within 4 corners. Now kindly take para 26. In view of the settled legal position, if the submission of counsel for revenue is correct, that tribunal has exercised power of review, the order passed by tribunal must be set aside. But if the tribunal has merely rectified a mistake apparent from record as submitted by so-and-so, it was within the power of tribunal and no grievance can be made against. What is a mistake apparent from the record? Now, my lord, kindly take, my lord, paragraph 30 to 33. Page 183 of the report. In our judgment, therefore, patent, manifest, and self, which does not require elaborate discussion of evidence or argument, it can be said to be an error apparent on face of and can be corrected while exercising certiorari jurisdiction. An error cannot be said to be apparent on the face if one has to travel beyond so and so. Then, my lord, paragraph 32. As stated earlier, decision was rendered in an appeal by income tax appellate. Miscellaneous application came under so and so, stating therein that the decision of the jurisdictional court, that is the High Court of Gujarat, was not brought to the notice and thus there was a mistake apparent. The core issue, therefore, is whether non-consideration of a decision of a jurisdictional course, that's Gujarat High Court or the Supreme Court, can be said to be a mistake. In our opinion, both the tribunal and High Court were right in holding that such a mistake can be said to be a mistake apparent from the record. A similar question came up before the High Court of Gujarat. It was held by division bench. Is covered by a decision rendered prior to or even subsequent to the order of. It cannot be. It could be said to be mistake. In our judgment, it is well settled that a judicial decision acts retrospectively. According to Blackstonian theory, it is not the function of the court to pronounce a new rule, but to maintain and expand the old one. In other words, judges do not make law, they only discover or find correct law. The law has always been the same. If a subsequent decision alters the earlier one, if the later decision does not make new law, it only discovers the correct principle of law which has to be applied. To put it differently, even where an earlier decision operated has quite some time, decision rendered later would have retrospective effect, clarifying the legal position. Then Mr. Saman is quoted, and it is no doubt true that after a historic decision in Golaknath, this court accepted the doctrine of prospective overruling. It is based on the philosophy the past cannot always be erased by a new judicial, may however be stated so and so. Then rectification and order stems from the fundamental that justice is above all, it is exercised to remove the error. Now, my lord, no dispute with this proposition. Yes. Because, my lord, at the end of the day, my lord, our argument is the removal has been done in accordance with the rules and regulation of the society. It is, my lord, an independent decision. It is, my lord, not dependent on any order. Yes. And, my lord, I've shown your lordships, my lord, the provisions of the rules and regulations. What? This is how it has been acted upon. 2/3 majority is all that was, my lord, required, which was there, my lord, on that date. So, my lord, this decision, my lord, really, my lord, has, my lord, no application. And secondly, my lord, in any event, my lord, I will show, my lord, from, my lord, the judgments which they have relied on, and I cited, my lord, one other judgment, my lord, of disqualification, my lord, earlier, that, my lord, if something has been done, my lord, in accordance with an order as existing, my lord, the day it's done, my lord, is valid. My lord, thereafter, my lord, if what follows, my lord, is, my lord, they have to take, my lord, independent action. My lord, similar, my lord, your lordships will find 2012, my lord, 13 Supreme Court cases 340. My lord, this is a case of a clarification. My lord, it's Union of India versus NR Parmar and others.
Two
2012, 13 Supreme Court cases.
240.
340.
Yes.
My lord, here, my lord, I don't know, my lord, how, my lord, this case is at all relevant. Number one, my lord, it does not relate to a judicial decision or a clarification given to a judicial decision. My lord, it relates to, my lord, it's a service matter where, my lord, the employer, my lord, had issued a memorandum, my lord, with regard to, my lord, the, my lord, it was an office memorandum, my lord, with regard to, my lord, seniority, my lord, in, my lord, the, my lord, posts. Your lordships will find that in 40.1, 41 and 42. Now, my lord, the office memorandum, my lord, kindly see, office memorandum is in the nature of clarification to so-and-so contained in office memorandum. The term available used in para so-and-so dated so-and-so has been clarified to mean both in case of direct recruits as well as promotees for the purpose of fixation of seniority would be the actual year of appointment after the declaration of results election, that is after the conclusion of the selection process and after completion of so-and-so. So, my lord, it was a clarification and not an amendment, because amendment, my lord, would operate prospectively. Clarification is, my lord, from the date of the original memorandum.
Correct.
But, my lord, this doesn't relate, my lord, to a court order. But assuming that is so, my lord, our case is, it's not done by virtue of only the court order. And in any event, my lord, the clarification which had been given related only to companies, not, my lord, to trusts or societies. Lastly, my lord, on this issue, my lord, they have relied on 2007, 3 Supreme Court cases, 557. My lord, this is, my lord, Supreme Court, my lord, P.V. George and others versus State of Kerala. My lord, this is a case of, my lord, prospective overruling. I'm sorry.
Two 2007.
2007, 3 Supreme Court cases, 557.
Yes. Yes.
My lord, this is, my lord, basically what it says, my lord, the courts, my lord, declare the law. So therefore, my lord, if, my lord, if a recruitment is made and it is made in while, my lord, if it is upheld, let us say first instance, but, my lord, ultimately, my lord, a decision comes, my lord, which says
Not correct.
that is not the law, then, my lord, recruitment goes. Now, my lord, at times, my lord, to protect, my lord, citizens' rights, my lord, who have, my lord, gone through, my lord, a spate of litigation, my lord, the court specifically provide, my lord, that the overruling is prospective in nature. Otherwise, my lord, it's retrospective because, my lord, the law is, my lord, what it was. And that is what is being declared. Now, my lord, here with the greatest of respect, my lord, no law has been declared with regard to rules and regulations of the society? None.
All the more, yes.
My lord, your lordships will find that, my lord, in para 19 to 21 and 29. My lord, like several tax matters, my lord, where, my lord, payments have happened, my lord, third-party rights, my lord, have intervened. Courts have said we are providing we are saying that it's prospective resolution. My lord, prospective overruling. Similarly, my lord, your lordships, my lord, aware, my lord, in my lord, Balco case, my lord, in arbitration, my lord, there again it was prospective, my lord, overruling of, my lord, the position in law. My lord, I'm not saying, my lord, anything is prospective. My lord, my argument is not that. My argument is it is not on the basis of any order that a particular status was resorted.
Yes.
It is by reason of a decision taken, my lord, by, my lord, members of the society.
The decision correct.
Correct.
Yes.
Now, my lord, kindly have a look at some of the cases, and this is, my lord, an alternate argument. My lord, is that assuming, my lord, it was under an order, my lord, on that date, my lord, this is what the law wanted. So, my lord, if he has gone on that date, he doesn't get reinstated automatically. That is, my lord, what I am relying on. My lord, that's 90. They have cited this case, 1995, 5 SCC 767. My lord, I relied on the disqualification case. Now, kindly have a look at their cases. 1995, my lord, this is VM Shah versus State of Maharashtra. 767, my lord, paragraph 11.
Just a minute. 1995.
1995. My lord, 5 Supreme Court cases, 767.
Seven six seven.
767, my lord.
Yes. Yes.
My lord, kindly see para 11. As seen, the civil court after full dress trial recorded the finding that the appellant had not come into possession through the company, but had independent tenancy rights from the principal landlord, and therefore the decree for eviction was negative. Until that finding is duly considered by the appellate court, after weighing the evidence afresh, and if it is so warranted reversed, the findings bind the parties. Now, my lord, assuming, my lord, here, my lord, I was, my lord, acting contrary, my lord, my lord, acted, my lord, on the basis of, my lord, of September 2020 and 1st October 2020. It was a decision, my lord, on, my lord, which is not just based, which is as a result of, my lord, those 2 orders. Now, my lord, if, so that those 2 orders, according to us, if it had to be obeyed, my lord, these are the steps which had to be taken. Now, my lord, when, my lord, the appeal is disposed of, and this is, my lord, very important, my lord, the reliefs which they pray for are not given.
That gone.
Yes. So, my lord, this, my lord, that they, my lord, automatically everything goes, doesn't work here. My lord, similar is, my lord, 1996, 1 Supreme Court cases 597. My lord, that's Kerala State Electricity Board. My lord, I'm not, my lord, troubling your lordship. My lord, it's the same proposition your lordship may make, my lord, or note, my lord, of that. Now, my lord, kindly take, my lord, 3 cases, my lord, where they've said, my lord, that if any order is without jurisdiction, my lord, it's a nullity. And therefore, my lord, they, my lord, don't need to challenge it. they can raise it in a collateral proceeding. Now, my lord, 3 cases they have relied on. My lord, one is, my lord, All India Reporter 1969 Supreme Court 823. My lord, the name of the case, my lord, is, my lord, Official Trustee, West Bengal versus Shochendranath Chatterjee. My lord, your lordship might have, my lord, the SCR reference 1969 3 SCR 92. Yeah, my lord, your lordship's been given the All India Reporter 1969 823 version, I'm told.
(1969).
Yes, my lord. Official Trustee, West Bengal versus Shochendranath Chatterjee.
Yes. What is the citation here?
My lord, citation should be All India Reporter 1969 Supreme Court 823, my lord.
Yes.
Now, my lord, I presume, my lord, the argument is that, my lord, a particular order which had been passed, my lord, was without jurisdiction. The court, my lord, now what is meant by, my lord, jurisdiction, my lord, in, my lord, the official trustee's case? This is very important because, my lord, we are not, for us, it's wholly irrelevant because we are not, my lord, saying, my lord, it was automatic. We are saying we took a resolution. Now, my lord, assuming, my lord, we are wrong and it was the order, kindly have a look, my lord, at para 12. What is, my lord, paras 12 to 15 and 29 is what I'm going to place. And this is very important, my lord, because it will show, my lord, that the argument is totally, with the greatest of respect, misconceived. Now, my lord, two, my lord, jurisdictional facts I want to indicate. And this is important, my lord. That first, my lord, para 12, my lord.
Actually, the citation in it is not.
My lord, does it start with it is plain? 68 here.
Because they have given this Supreme Court Reporter 16 SCR.
Oh, they have not given AIR, no, SCR.
It's not AIR, it is SCR.
They have a copy of it. SCR, my lord, that won't have paragraph number.
Paragraph, there's no paragraph.
My lord, kindly come to. My lord, kindly give me a moment. My lord, kindly come to page 99, placetum B, my lord.
Yes.
Lordship has that, my lord. It is plain.
Yes.
তোমার কাছে এটা করে নাও না। Airdrop ছিল না, এটা airdrop করে নাও। My lord, kindly see, my lord, it is plain that if the learned judge had no jurisdiction to pass the order in question, then the order is null and void. It is equally plain that if he had jurisdiction to pronounce on the plea put forward before him, the fact that he made an incorrect order or even an illegal order, kindly note this, cannot affect its validity. Therefore, all that we have to see is whether Justice Ramphey had jurisdiction to kindly mark the words, to entertain the application made by the settlor. This was, my lord, under 34 of the Trust Act, whether he had jurisdiction. Now, my lord, three important facts here, my lord, if what they are saying, my lord, what they are seeking to rely on. Now, my lord, the testamentary jurisdiction of this High Court has been invoked for the grant of probate. And then later, my lord, letters of administration with will annexed. There is no dispute that, my lord, as far as the will is concerned, this honorable court, my lord, has jurisdiction, my lord, to, my lord, either grant of probate or letters of administration. Now, my lord, if that is the case, my lord, this court can entertain, my lord, an application under section 247 for, my lord, appointment of administrator pendent electing. Now, my lord, it is also established, my lord, that this court in, my lord, a probate proceedings can prima facie, my lord, determine what is the subject matter of the estate. Now, my lord, if it has decided something wrongly, that this is not the, my lord, said X is the subject matter of the estate, and later it is found, my lord, that, my lord, no,
it is not correct.
It is not. My lord, that's a wrong order. It might even be an illegal order. But, my lord, the court had jurisdiction to entertain the application and decide it. It's not, my lord, an order, my lord, which is without jurisdiction and therefore null and void.
Got you.
My lord, there has to be, my lord, lack of subject matter jurisdiction. And which is nobody's case, my lord, that this is, my lord, lack of subject matter jurisdiction. Now, kindly see para 30.
Yes.
What is meant by jurisdiction? This question is answered by Acting Chief Justice Mukherjee speaking for the full bench of the Calcutta High Court in Hridaynath Roy and Ramchandra Bodno Sharma. At page 146 of the report, the learned judge explained what exactly is meant by jurisdiction. We can do no better than to quote his words. In the order of reference to a full bench in the case of Suklal and Tarachand, it was stated that jurisdiction may be defined to be the power of a court to do what? To hear and determine a cause, to adjudicate and exercise any judicial power in relation to it. In other words, by jurisdiction is meant the authority which a court has to decide matters that are litigated before it, or to take cognizance of matters presented in a formal way for its decision. An examination of the cases in the books discloses numerous attempts to define the term jurisdiction, which has been stated to be what? The power to hear and determine issues of law and fact. The authority by which the judicial officer takes cognizance of and decides causes. The authority to hear and decide a legal controversy. The power to hear and determine the subject matter in controversy between the parties to a suit, and to adjudicate or exercise in a judicial power over them. The power to hear, determine, and pronounce judgment on the issues before the court. The power or authority which is conferred upon a court by the legislature to hear and determine causes between the parties and to carry the judgments into effect. The power to inquire into the facts to apply the law, to pronounce the judgment, and to carry it into execution. Proceeding further, the learned judge observed the jurisdiction of the court may be qualified or restricted by a variety of circumstances. Thus, the jurisdiction may have to be considered with reference to place, value, and nature of subject matter. The power of a tribunal may be exercised within defined territorial limits. Its cognizance may be restricted to subject matters of prescribed value. It may be competent to deal with controversies of a specified character. For instance, testamentary or matrimonial causes, acquisition of lands for public purposes, record of rights as between landlords and tenants. This classification into territorial jurisdiction, pecuniary jurisdiction, and a jurisdiction of the subject matter is obviously of a fundamental character. Given such jurisdiction, we must be careful to distinguish exercise of jurisdiction from existence of jurisdiction. For fundamentally different are the consequences of failure to comply with statutory requirements in the assumption and in the exercise of jurisdiction. To the authority to decide a cause at all and not the decision rendered therein is what makes up jurisdiction. And when there is jurisdiction of the person and subject matter, the decision of all other questions arising in the case is but an exercise of that jurisdiction. The extent to which the conditions essential for creating and raising the jurisdiction of the court or the restraints attaching to the mode of exercise of that jurisdiction should be included in the conception of jurisdiction itself. It is sometimes a question of great nicety, as is illustrated by the decisions reviewed in the order of reference in Suklal, etc. Also observation of Lord Parker and Raghunath. We must not thus overlook the cardinal position that in order that jurisdiction may be exercised, there must be a case legally before the court and a hearing as well as a determination. A judgment pronounced by a court without jurisdiction is void, subject to the well-known reservation that when the jurisdiction of a court is challenged, the court is competent to determine the question of jurisdiction, though the result of the inquiry may be that it has no jurisdiction to deal with the matter before it. Finally, the learned judge quoted with approval the decision of Justice Srinivas Iyengar in Tuljaram versus Gopala, where Justice Iyengar laid down that if a court has jurisdiction to try a suit and has authority to pass orders of a particular kind, the fact that it has passed an order which it should not have made in the circumstance of the litigation does not indicate total want or loss of jurisdiction so as to render the order a nullity. From the above discussion, it is clear that before a court can be held to have jurisdiction to decide a particular matter, it must not only have jurisdiction to try the suit brought, but must also have the authority to pass the orders sought for. It is not sufficient that it has some jurisdiction in relation to subject matter. Its jurisdiction must include the power to hear and decide the questions at issue, the authority to hear and decide the particular controversy that has arisen between the parties. Therefore, the fact that Justice Ramfree had jurisdiction to pass certain orders either under the Indian Trust Act or Official Trustees Act or under Trustees and or under his inherent power is not conclusive of the matter. What is relevant is whether he had the power to grant the relief asked for in the application made by the settlor. That, we think, is the essence of the matter. It cannot be disputed that if it is held that the learned judge had competence to pronounce on the issue presented for his decision, then the fact that he decided that issue illegally or incorrectly is wholly besides the point. Therefore, we have now to see whether the learned judge had jurisdiction to decide the issue presented for his determination. The relief prayed for, as seen earlier, was to permit the settlor to revoke particular clauses in the trust deed and authorize him to alter the quantum of interest given to each of the beneficiaries. Had the learned judge jurisdiction to entertain those pleas? This is, my lord, the most important thing. Now kindly take para 29, my lord. Oh, my lord, I'm sorry, my lord, I'll just...
From whatever.
Whatever.
Yeah, this is the.
My lord, page 106.
Yes.
My lord, kindly see, my lord, the sentence starting from whatever angle. Your lordship has that, my lord?
From whatever.
Yes, from whatever angle we may examine the validity of the order made by Justice Ramfree, it appears clear to us that the said order was outside the jurisdiction of the learned judge. It was not merely a wrong order or an illegal order. It was an order which had no competence to make, It is not merely an order that he should not have passed, but it is an order that he could not have passed and therefore a void order. So, my lord, subject matter jurisdiction had to be there. Now, my lord, kindly come to, my lord, the division bench order. My lord, which is, my lord, in that compilation, my lord, I gave your lordships. My lord, the order of 14 December 2023, which is at page 124 of the compilation. Kindly come to, my lord. My lord, the issues first. My lord, which are, my lord, at page 62. No, sorry. Page 349, my lord, kindly have a look. My lord, 3 for upon a scrutiny of the so-and-so, certain dates acquire relevance given out of labyrinth of arguments the following broad issues. Power of probate court under 247. Question of title, third party injunction, extent of PDB estate, so-and-so, APL administrator pendente lite, powers. And that too relating to company. Now kindly have a look at page 414, my lord, para. My lord, 413, para 200.
Yes.
Thus, the issues formulated above are answered as follows. A testamentary court cannot decide issues of title conclusively. Such power lies purely within the domain of civil courts. Now kindly see the next. However, while deciding an application under so-and-so for appointment of administrator pendente lite, the testamentary court
May decide the extent of the
testamentary court may decide the extent of the estate of the deceased testator, testatrix prima facie. So it had jurisdiction, my lord, to entertain, my lord, an objection with regard to title. Then, my lord, 202. Third party injunctions can be granted by testamentary courts in exceptional cases for the limited purpose of protecting the estate so and so. However, under normal circumstances, testamentary court cannot interfere in internal affairs of third party companies. So, my lord, I am showing your lordships, my lord, that, my lord, there is complete jurisdiction. My lord, learned single judge order, my lord, might have been partially wrong. Now, my lord, kindly see issue 2-1. The estate of PDB is comprised of actual shares owned by her during her lifetime in various companies, then, my lord, trusts and other entities, as well as consequential powers which such ownership carries as its incidence. Then, in so far as companies are concerned, they can so and so. Here also. Then, my lord, issue 2, controlling interest is referable to shares as far as companies are concerned. Issue 2-3. Then, my lord, 206. Issue as to what is estate is not barred by, my lord, res judicata. Then, my lord, 419, issue 3-1.
Yes.
Now, my lord, in this case, my lord, the court found, not that, my lord, there's one thing to say, that a testamentary court cannot make an inquiry as to, my lord, whether, my lord, the estate has, my lord, controlling rights, etc. But in this case, they had that they cannot interfere with internal affairs, 212, of all the tiers with blessings of the testamentary court. Page 420, para 212. Thus, the APL thus cannot interfere with all internal affairs of companies of all the tiers. There were 3 tiers. My lord, for 1 and 2, it's fine. But for 3, they said tier 3, you cannot. It's on the facts. 3 and 4. My lord, these are jurisdictional issues which have been decided in favor that all these, my lord, can be gone into. If an order, my lord, of a learned single judge is wrong or even illegal, that doesn't, my lord, make it null and void because, my lord, it had no jurisdiction. It had jurisdiction, my lord, to decide. So therefore, my lord, the most important thing is, my lord, even in collateral proceedings, my lord, they cannot challenge, my lord, any of the orders or directions, or, my lord, any actions taken on that basis.
Yes.
They have to now, my lord, file, my lord, a suit. In every other trust case, my lord, they file suits. This is the only one where they haven't. And, my lord, your lordship should be told that, my lord, giving them the benefit, my lord, of, my lord, the exclusion period during COVID, my lord, the law of limitation has also stepped in. My lord, they cannot challenge it in a different suit. 16th April is unchallenged. They can't do it in a collateral proceeding. They've been relying on these cases to say, look, this is order which is null and void. I don't need to go anywhere else. And steps have been taken pursuant to that order. I'm saying no. The court had jurisdiction, my lord, to determine the issues. The greatest of respect, my lord, it's not an order which is void ab initio.
Yes.
It's not null and void on the date it's pronounced.
Yes.
May I come back tomorrow, my lord? 3 o'clock, your lordship has a matter.
कल है कल भी fix है suffering for the plaintiff, suffering for the defendants. Counsel for the plaintiff has argued the matter at length, but due to paucity of time, hearing could not be completed. The matter is already fixed tomorrow. Please the matter tomorrow at 2 p.m. कब तक निकलना है लास्ट Yes. Commercial.
No.
এই চেয়ারটাকে না একটু রিপ্লেস করবেন মানে কোনো সিনিয়র লোক পড়ে যাবে সরিয়ে দেন সাইডে পেছনে দিয়ে দেন হ্যাঁ তাই দেখুন And I appear for the propounder, but my learned friend is making submission.
I was continuing. Right. I was, Lordship, on the last occasion, I have gave the structure on the basis of which I shall be arguing. And my lord, straight away I shall rely on one decision of the Honorable Supreme Court, 2009 3 SCC, page 687. Paragraph 23. 9-3 SCC. 687.
Yes.
Lordship, paragraph 23. Lordship, Supreme Court, Lordship, Lordship, noticed various decisions of, and thereafter, Lordship had summarized at paragraph 23. Lordship, this is obviously, Lordship, not exhaustive, but some of the suspicious circumstances which may arise. Suspicious circumstances like the following may be found to be surrounded in the execution of the will. Number one, the signature of the testator may be very shaky and doubtful or not appear to be his usual signature. Number
22, the condition of testator's mind may be very feeble and debilitated at the relevant time. The disposition may be unnatural, improbable, or unfair in the light of relevant circumstances like exclusion of or absence of adequate provisions for the natural heirs without any reason. The dispositions may not appear to be the result of the testator's free will and mind. The propounder takes a prominent part in the execution of the will. The testator used to sign blank papers. The will did not see the light of the day for long. Incorrect recitals of essential facts. Worship, out of this, kindly marks 1, 2, 5, and 7 are definitely relevant. 1, 2, 5, and 7 are definitely relevant for our case. Although the signature is shaky, the condition of testator's mind may be feeble. At the relevant point of time, the propounder takes a prominent part, and the will did not see the light of the day for long. These are, and 8 also, incorrect recitals of essential facts. So on the last occasion, I was on incorrect recitals of essential facts. I was making my submissions. So, these are, according to Supreme Court, these are the may constitute suspicious circumstances, and it is for the propounder to remove the remove all the suspicious circumstances. I shall also rely on another Supreme Court decision, 2022 Volume 3 SCC, page 209. It's a very settled position of law, which I just paragraph 32. This is a very settled position of law. That is why I'm placing only one paragraph of this decision. It's the latest decision, taking into account, Lordship, the last decision, the Bharpur Singh case. This takes into account Bharpur Singh case in paragraph 33, but paragraph 32, Lordship will kindly see. In fact, the legal principles with regard to the proof of a will are no longer res integra. Section 63 of the Succession Act 1925 and Section 68 of the Evidence Act are relevant in this regard. The propounder of the will must examine one or more attesting witnesses, and the onus is placed on the propounder to remove all suspicious circumstances with regard to the execution of the will. So, the onus is on the propounder to remove all doubts with respect to any suspicious circumstances that may be seen. So, I have already Lordship submitted about the delay, which is also present in the Bharpur Singh case, which says that incorrect, the will did not see the light of day for long. Okay, with respect to the delay, Lordship, I have already made my submissions. But I was on the last occasion, since Lordship inviting Lordship, I was submitting on the issue of incorrect recitals. Lordship kindly takes the will. Lordship kindly takes the judge's brief of documents, my lord. I shall place from the judge's brief of documents. There are two judges' brief, my lord. The one, my lord, the fat one. Lordship kindly takes page 2 of the judge's brief. This is the first page. Yes. The first incorrect recital is at page 1, which is A. I give, devise, bequeath all the piece and parcel of land measuring up to 30 kattas with all building and structures thereon, premises number 2. Lordship, by this, my lord, the testator bequeaths the property as if she is the full owner of this property.
Yes.
Lordship, apropos this, my lord, Lordship kindly sees the second judge's brief, my lord. Exhibit 1.
Second judge.
পাতলা মতো আছে judge's brief থেকে দেখো না কি আমারটা কোথায়
क्या second judge brief है? Yes.
Lordship page আমি পাইনি আছে তোমারটা
Second judge brief having only 2 documents, no?
Lordship. Lordship kindly takes the first document, which is an application under RTI.
Yes.
Please issue me the information in writing about the devolution of recorded owner since 72 to 2015 against Kolkata Municipal Corporation, premises number 2 Tangra 2nd Lane. Please issue me the information in writing how Mr. Indojit Banerjee got mutated. PD case number June 13 765 dated 28th June 2013.
This is exhibited.
This is exhibit, both are exhibit 1, my lord. The first document and the first page and second page. Lordship kindly turns, my lord, to the next page, which is the reply to the RTI application. Two very vital facts, Lordship, emerge.
Yes, you already argued.
Lordship, I have argued. Lordship, I'm just recapitulating. One is the name of the recorded owner is Priyolal Banerjee and Kiranbala Devi Banerjee. So, my lord, Priyolal Banerjee was 50% owner of this land and Kiranbala Devi Banerjee was 50% owner. So, my lord, the first incorrect recital is that she is not the full owner, but she bequeaths the property as if she is the full owner. This is, Lordship, the first mistake. Lordship, apropos this, kindly sees the question, Lordship, since I am on this topic, Lordship, I shall complete everything, Lordship. The question 248 and 249 put to the defendant's witness. That was done in commission.
Forty.
248 and 249. These are the only two questions put in cross-examination with respect to the title of the property in question.
Yes.
248. In question 67 of your examination, Chief, you have said that there are two owners of the residential house, namely Kiranbala Devi and her stepson Priyolal Banerjee. Do you find that? Yes. I suggest to you that the ownership of the residential house as held by Priyolal Banerjee was surrendered by him in favor of Kiranbala Devi during a litigation pending before Calcutta High Court, where after the residential house solely belonged to Kiranbala Devi. I disagree. So, these are the only question which had been put. No document was.
This is a cross-examination.
This is cross-examination of the defendant's witness, my lord.
Examination, you said that there are two owners of the residential house, Kiranbala and her stepson Priyolal. Do you find? Yes. Suggest you that ownership of residential as held by the Priyolal was surrendered by him in favor of Kiranbala Devi during the litigation pending before the Calcutta High Court. I disagree.
Yes. So, no document, lordship, exhibited, not even confronted with. And my lord, obviously, this is the first time this alleged story ever came to light. This was never, lordship, even pleaded or tried to prove that Kiranbala Devi became the full owner by in some proceeding.
No, it might be not pleaded because it is your case, because they have made a specific case with regard to the will. You come within your affidavit.
Lordship.
Correct. And you have taken the plea that yes, it is not only the Kiranbala, it is with regard to Priyolal.
Priyolal.
Correct. Now, During the cross-examination, they can put the question, but only
They can
the
put,
question.
but they have to, Lordship, confront with
The
documents,
defense
Lordship.
which, only the question is that the defense which they have taken, whether that has been proved or not.
Lordship. And there are, in that regard, I have produced a document from Kolkata Municipal Corporation. And here, my lord, there is only a suggestion. Other than the suggestion, there is nothing.
Okay.
So, my lord, the fact that Kiranbala Devi was not the full owner, was in my humble submission, my lord, that was established. Second, my lord, kindly sees the will again, the incorrectness in the will. Lordship, page 1 again. Sorry, my lord, I am going to.
Yes, yes.
Lordship, kindly sees the second line of page 1. What is the name of Kiranbala Devi?
Where you are reading?
Lordship, page 1 of the will.
Kiranbala Devi alias Kiranbala
Lordship.
Banerjee.
Lordship, there are 3 mistakes in this. Kiranbala Devi alias Kiranbala Banerjee. Number 1, Lordship, she always used to sign. Lordship may compare this. They have tried to prove Kiranbala Devi's signature by way of comparing with Exhibit H, which is at page 17.
Page 17 of?
Page 17 of the judge's brief.
JBD. Yes.
Lordship will see the spelling of Devi. It is with D-E-B-Y. And here it is D-E-B-I. Secondly, Kiran and Bala.
Whether page 17 is exhibit document?
It is Exhibit H.
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 And will is exhibit C.
Exhibit C, my lord.
Yes. Yes, exhibit C. Exhibit.
So the
H.
comparison of Exhibit C with Exhibit H would reveal that even the name of the testatrix was not put correctly. Kiran Bala Devi. Kiran and Bala are separate. Devi is with a Y, but in this case it is Kiran Bala together and Devi with an I.
Yes.
And the last incorrectness is that Kiran Bala Banerjee. Lordship, there is no evidence, either oral or documentary, that Kiran Bala Devi used to sign as Kiran Bala Banerjee also. She never used this name, Kiran Bala Banerjee.
Yes.
The third incorrect recital is at page 3, paragraph F, where she describes Priyolal Banerjee to be her eldest son.
Page 3?
Page 3 of the will. Paragraph F.
Eldest son, Indrajit Banerjee.
Eldest son, no, my lord. Eldest son, Priyolal Banerjee.
Where?
Paragraph F. Page 3, paragraph F of the will. Page 5 of the judge's brief.
Yes. I was paragraph F.
Paragraph F. I was required to make payment of rupees 50,000 to my eldest son, Priyolal Banerjee. This is another incorrectness. She describes Priyolal Banerjee to be her eldest son, whereas she is her stepson, and our eldest son is Munilal Banerjee.
What is the name?
Munilal Banerjee.
Muni.
Muni. M-O-N-I.
Yes.
This is with respect to the wrong recital. Lordship, kindly now, my lord, I shall place few questions from the deposition of PW2, who is the propounder. PW2, my lord.
Evidence.
The evidence, my lord. Few questions.
What is the name?
Indranath Banerjee. Indrajit Banerjee, I'm sorry, my lord.
Indrajit Banerjee. सीरियल करके ना टैग कर दो 1 2 3 ऐसा ना टैग कर दो
Lordship, kindly takes page question 38.
Yeah, PW2.
PW2. PW1 was a handwriting expert who was used only to prove a signature of one of the attesting witnesses.
Yes.
Question number 38. 38 to 40, Lordship will see. Where did you find this letter from? After the death of my mother, Lordship, this is with respect to Exhibit H.
Yes.
After the death of my mother, sometime in May 2014, when I opened her almirah, I found the original will along with some original documents in her locker, and this was part of those documents. So May 2014, he discovers. When did your mother die? On 14th April 2013. And when did you discover this document? Sometime in May 2014. Thereafter, Lordship kindly takes question 46. Lordship, this is extremely crucial. Question number 46.
Yes.
Did your parents Deepak Banerjee, alias Diptilal Banerjee and Ranu Banerjee, prior to their death, apply for letter of administration in respect of this will? No. To the best of my knowledge, they had not applied any letter of administration because the original will was discovered in the almirah sometime in May 2014. So, the deposition is that the will was discovered for the first time in May 2014. So, I could not have, neither me nor my parents could have applied for the letters of administration. Now how it will change, Lordship will kindly see. 46, 47. Is this place same where you just now said that you discovered the letter and some documents? Yes, all original documents were in the same almirah. Which kindly takes now question 77. 77 to 81. Was also with respect to the so-called discovery of the original will. Or when did you have the occasion to mutate this property in your name? Sometimes after my mother expired in April 2013, I was under serious depression. I was unwell after death of my grandfather. This should be mother. I was unwell after the death of my mother. And when my wife was organizing her room in which she lived, she found a bunch of keys in my
Mother or
mother's.
grandmother?
It was the testatrix is the grandmother, but he was suffering from depression after the death of his mother.
It is mother.
It is mother. This should be grandfather, should be read as mother. And when my wife was organizing her room in which she lived, she found a bunch of keys in my mother's vanity bag and opened wooden almirah to organize it. While organizing her personal effects, she found photocopy of a will. Then what did you do? I was having lot of problems at that point of time. I was also having some issues with the company and also having issues with taxes. And since I was paying all corporation taxes, I approached Kolkata Municipal Corporation to mutate the property in my name. Why did you have to mutate the property in your name alone? The property was out of many properties given to me by my father and was clearly written that after my father it will come to me. Since Kolkata Municipal Corporation taxes had to be paid on regular basis, I had taken care of all my tax payments be paid. I was strongly advised then to mutate the property in my name. You have stated in your application for letter of administration that you have come to find the original will in May 2014. Yes. How do you correlate the two? When I said that my wife discovered the photocopy of the will from my mother's wooden almirah, I did not have the original document. In May 2014, when I opened the room and when I opened the almirah and lock of the almirah, the original will along with other original documents were discovered. So, this is in the witness already said in last on the where I showed that in May 2014 he discovered the original will. But it was later on discovered that his mutation was before May 2014. So he had to give an explanation. The explanation was that he found a photocopy of the will in April 2013 and with the photocopy he mutated the property. Now, my lord, kindly sees the cross-examination in this regard. 186. Actually, on the last occasion, I have shown paragraph 8 of the plaint, where the plaintiff has stated that there was only one person who is there today, that is one Madhusudhan Parida, who had seen the execution of the will. Lordship, with this, apropos that, Lordship, question 186 starts. What did your mother do after Madhusudhan Parida told her that your grandmother had allegedly executed a will in his presence? My mother was very ill before she died, and she mentioned that the original will was handed over to my parents, Baba and Ma, by my Shejo Jethu, and also mentioned that Madhusudhan Parida would have seen some documents being signed by advocates and my grandmother. Similar discovery of original will in May 2014. The first blow is that mother knew. Now he confesses that mother somehow knew that the original will was handed over to my parents by my Shejo Jethu. Shejo Jethu is the executor, Malad. The one Fonilal. What would be the age of Madhusudhan? Lordship, that is not important.
No, so what you want to 186? What you want to prove that? What did your mother do after the Madhusudhan Parida?
Yes. So, Malad,
that your grandmother.
The evidence was, if I may explain. First, May 2014, I discovered the will. So I could not have, neither me nor my parents could have discovered about the will. So, my lord, how did the plaintiff come to know that Madhusudhan Parida was present? Because his parents are no more. As on date, his parents are no more. How did the plaintiff come to know that Madhusudhan Parida and nobody else? Lordship, that is the exact language in paragraph 8. No, none but Madhusudhan Parida.
So this is a cross-examination.
Lordship.
Correct.
So, my lord, how did the plaintiff come to know? That was the cross-examination. How did the plaintiff come to know that Madhusudhan Parida was present? Either he was also present to know that Madhusudhan Parida was present, or he must have been told by somebody. So then who has told? That is the question.
So where the name of Madhusudhan Parida came in the chief?
Lordship. No, in the chief, it doesn't appear. It is in
this
paragraph.
Is your question. So that's why it is your question.
Lordship.
It is a question of defendant.
Lordship,
so
kindly.
You have put the question with regard to the Madhusudhan Parida and he has given the answer.
Lordship, Lordship, why I put the question, Lordship, may I place paragraph 8 of the plaint? Lordship, need not take paragraph 8. Lordship, may I place it? It's a very short paragraph. The will is proved by the affidavit of Sri Madhusudhan Parida.
Correct.
Son of late Sudarshan Parida, such and such, and also at the attending witness of the last will and testament dated 18 July 1986 as the named attesting witnesses, namely Mihir Kumar Dotto, Shitesh Sinha, in the said last will, both have already died. And there are none to adduce evidence save and except the said attending witness, which is filed herewith and by his declaration signed at the foot of the petition.
Correct.
So, my lord, there is none save and to adduce evidence save and except attending witness. Lordship, I have on the last occasion I said that Madhusudhan was not even examined.
Correct.
So, my lord,
So if
this
the
this fact that there was none other than Madhusudan Parida to say this, Lordship, there must be somebody who has told this to the plaintiff.
Correct.
Because the plaintiff at that point of time, the plaintiff discovered in May 2014. So how did he knew before May 2014 that Madhusudan Parida had seen this? The answer, Lordship, when the question came that, Lordship, may I place this a little before, my lord? May I place the questions from page 173?
Yes.
Lordship, you have stated in your application for obtaining the letters of administration that Madhusudan Parida was present at the time of execution of the will. On what basis you had said so? This was on the basis of my understanding that he used to live in the house. Why did Madhusudan Parida live in the house? His grandfather also lived in the house. He also lived in the house. He used to do some household work when he was in the house. Is it your evidence that the father of Madhusudan Parida worked for your family? No. Then what household work did father of Madhusudan Parida do? The father of Madhusudan Parida never lived in the house. His grandfather used to live in the house. Why did grandfather of Madhusudan Parida live in the house? I cannot say. My grandmother provided her space for him to live there. What household work would grandfather of Madhusudan Parida do? I cannot say. Did you see grandfather of Madhusudan Parida? Yes, I did. At that point of time, did you see him doing any household work? I cannot remember clearly, but once in a while, he used to work in the garden. Can I take it that the grandfather of Madhusudan Parida was a gardener at your house? He was not appointed a gardener, but at his will and wishes, he used to tend to the garden at times. What do you mean by the words appointed gardener? Appointed means he was not paid, if I remember correctly, any money for being gardener. How did you come to know he was not paid? As I mentioned, that is from my recollection. What is the basis of the recollection? Whatever my memory serves. Is Madhusudan Parida still living in your house? Right now, he is not there. What did your mother do after Madhusudan Parida told her that your grandmother has allegedly executed a will in his presence? My mother was very ill before she died, and she mentioned that the original will was handed over to my parents by my Shejo Jethu, and also mentioned that Madhusudan Parida would have seen some documents being signed by advocates and by my grandmother.
So that's why I'm not.
So
that's why I'm asking the question to you. What did your mother do after Madhusudan Parida told her? Where from you got that the Madhusudan Parida told her that your grandfather has allegedly executed a will in his presence? Where from you got this?
Lordship, this must have been some
You have
portion
put
must
this
have been
question.
left out at that point of time.
First thing that.
But
Second thing,
there is a
Madhusudan has not been examined. So nothing, what presumption you will take from this answer or
the
question?
presumption is, well, this is I'm on
Because
the issue that
Madhusudan is not examined. So
Lordship,
attending witness not examined. Whatever the proponder or plaintiff or whatever it may he has stated before this court, nothing. What is the value of that evidence?
no evidence at all.
So
I am on the.
If the Madhusudan was examined, then you can corroborate this or distinguish this, whatever it may. But Madhusudan has not been examined.
No, I am on Malad, the will did not see the light of the day for long. I'm on that point. So, my lord, he says that will did not see. He gives an explanation. He has to dispel all doubts. He has to remove the suspicious circumstances. In chief, he says, in May 2014, I have discovered that is why the will did not see the light of the day
Till
for
May 14.
21 years.
Till 14.
For
Till
21 years,
2014, will was in the Almira.
Came to the knowledge.
And 14.
But and also, Lordship would recall, the evidence was my parents could not have done it because original will was discovered. So
that is
the another evidence was even my parents did not know about the will.
Correct.
But 186 says that not only my parents knew, not only mother, Baba and Ma, Lordship, Baba and Ma, Lordship is written, not only my parents knew, they were handed over the original will. So original will comes again before May 2014. My mother was very ill, and before she died, she mentioned that the original will was handed over to my parents by my Shejo Jethu, and also mentioned Madhusudhan Parida would have seen some documents being signed by my advocates. So the point is, even before May 2014, the original will not only came in the possession of the parents of the plaintiff, yes, of the plaintiff, but it was also told to the plaintiff also by the mother.
Yes.
And who has seen? Madhusudhan Parida has seen, who was never examined.
Yes.
This is question 186. Now, my lord, kindly takes question 192 thereafter. When did your parents receive the will from your Shejajitu? I would not be exactly aware of the dates. Since your father died on 1st September 2005, would you agree it must be before that date? Yes. So, my lord, before 2005, they knew. They had the original will in their possession. So, my lord, question number 46, where he says that my parents, the explanation which he gives about the suspicious circumstance of the delay is completely falsified. Because before 2005, Shivji Jyoti has allegedly handed over it to them. And this was filed in 2014.
Yes.
Now I again question, and I should not have, was the original will given to your parents or the photocopy? As my mother mentioned, it was the original will, very truthful witness. He stuck to it. Original will. So, my lord, before 2005, at least before 2005, the original will was with him. So, question 46, the so-called explanation of the suspicious circumstances goes.
2015.
2005.
2005 they had.
Lordship, before 2005, they had. 2014, the present proceeding has been filed. Now, my lord, so the executor handed over the will to the parents did not do anything. Then what did the attesting witnesses do? My lord, with respect to that, kindly comes to question number 126. Then nobody told anything to this person. The attending witness did not come. The attesting witnesses did not say anything. The executor hands over the original will. The parent sits tight. My lord, now this is unbelievable. That is my contention. Question 126. You have said that Dr. Mihir Kumar Dotto was your, the Lordship Mihir Kumar Dotto is one of the attesting witnesses. He's a doctor. Was your family physician? What do you mean by family? He used to treat my mother, my father, my grandmother. He also treated my Shejo Jatha, Mr. Fonilal Banerjee, the executor. How often would Dr. Dotto visit your family? As the best of my knowledge, he visited to check my grandmother almost in every short intervals. What do you mean by short intervals? Every 7 to 10 days. When do you last meet Dr. Dotto? It is very difficult for me to exactly say the dates. But I also have been to his chamber in Belegata whenever I need him to consult. Can you tell at least which month or year throughout the 90s? After 2000? After 2000, perhaps I may have been to his chamber. Why was Dr. Dotto made a witness in the alleged will of your grandmother? Can you say? I cannot say. So, Dr. Mihir Kumar Dotto, he is regularly in touch, goes to him for consulting. Dr. Mihir Kumar Dotto also says nothing to him. Now, Malad, the other witness, Mr. Shitesh Sinha, who is an advocate. Do you know Mr. Shitesh Sinha, advocate? I have met him a couple of times. Can you tell this honorable court? When did you meet him? I cannot remember the dates. Can you remember the year? Sometimes in 1980. So 1980 is before the will. He is an advocate of Calcutta High Court. What business did you have with Mr. Kshitij Sinha, advocate? He was known to me through a common acquaintance. Can you name the person? Advocate Shamarjit Gupta. So Shamarjit Gupta is the advocate who has drafted the will. He has signed as drafted the will. Why was Mr. Kshitij Sinha, advocate, made a witness in the alleged will of your grandmother? I cannot say. Did Mr. Kshitij Sinha, advocate, know your grandmother? I can neither confirm nor deny. So, my lord, the second attesting witness, Mr. Kshitij Sinha, advocate, was an acquaintance of the plaintiff himself. He was introduced to Kshitij Sinha through Mr. Shamarjit Gupta. And who is Shamarjit Gupta? Lordship will see the will at the bottom on the last page, page 7 of the will. Page 7 bottom.
Yes.
Drawn by Shamarjit Gupta. Lordship will see. It is, the signature is at the bottom. Advocate 7B something road, Kolkata 29.
He was not examined.
No. I do not know also whether he was alive or not.
One of the attesting witnesses were alive.
Attesting, drafting, attending. So, my lord, so Mihir Kumar Datta regularly visited. He also did not say anything to the plaintiff or the plaintiff's parents that about the execution of the will. The Kshitij Sinha is my acquaintance. My acquaintance also keeps mum about the execution of the will, and he specifically refuses to answer. Did Mr. Kshitij Sinha, advocate, know your grandmother? I can neither confirm nor deny. So, that is with respect to the attesting witnesses. Now, Lordship will see how the witness, the plaintiff answers with respect to his presence at the time of execution of the will. Lordship kindly takes. I was somewhere in the house. Oh. Excuse me. I was somewhere in the house. 86 to 80. Lordship kindly takes question 86
of
PW2. This is cross-examination.
Yes.
In answer to question put to you in examination, chief, you have stated that you went to obtain letter of admit. No, this would be letter for your grandmother's. No. Lordship, question number 87, my lord. Were you present at the time of execution of the will by your grandmother Kiranbala Devi? No. Similar, he is not present. Whether you had seen your grandmother sign the will, I have not seen my grandmother sign on this particular document, but I was somewhere in the house. You had also not seen other witnesses sign this document as the attesting witness? No, I was, there should be a not. No, I was not present in the room. You cannot say who was the person present at the time of execution of the will. I cannot immediately recollect who exactly were present inside the room. So, Lordship, this was the evidence that he was not in the room. But apropos this, Lordship, his acquaintance, Sitish Sinha advocate, comes to the house. His acquaintance, Shamarjit Gupta, comes to the house for execution of the will. And he is not present in the room. The witness, Lordship, maybe he was present in the room, maybe not, but he, for some reason, deliberately disowns the signature of Kiranbala Devi.
Where is the suggestion? You are deliberately have stated that you are present, but you deliberately deny that you are not present.
No, I'm not saying that whether he was present. I'm saying that this entire will is procured.
That is different thing. If you are putting this brought to the notice of this court that he has stated that he was not present, and he is making a deliberate false statement before this court. But where is the cross-examination or giving suggestion you were present at the time of execution of the will, but you have made a false statement?
That suggestion that he has made a false statement, that I have
he
made.
was present, but
Lordship, my point is something different. I am saying that the plaintiff, very carefully, he is not admitting to identify the signature of Kiranbala Devi at the time of the will. He has very categorically has said that he is not admitting. But, my lord, he was somewhere in the house. His advocate comes, his friend comes, and everything is happening in his house. But, Lordship, this is, for some reason, Lordship, my case is that Kiranbala Devi did not put her signature, for reason of which she did not want to adduce in evidence in court, Lordship, that he has seen Kiranbala Devi sign.
Correct.
Lordship, that would be my submission apropos this.
How much time will take?
Lordship, another 15 minutes or so.
Witness है कल है ये come tomorrow.
Yeah, I have prepared a notes of argument. I shall also submit that tomorrow.
I will add only 5 minutes.
I am led by Mr. Bosmal.
No problem. Consensus and suffering for the plaintiff, consensus and suffering for the defendant. Counsel for the defendant has argued the matter at length, but due to paucity of time, hearing could not be argument could not be completed. Case adjourned. The matter is already fixed tomorrow at 3. 3 p.m. Please the matter tomorrow at 3 p.m.
No, try to fix it. Only one.
Yes.
I'm grateful, man.
345, I don't know, 5 for the non-government.
I had taken out this application, my lord, revocation of 92 leave. Lord, I have been led by Mr. Ghosh, Devnath Ghosh. He has completed his argument. Mr. Rai, my lord.
The GA1 should have been heard first. And since he's on the petitioner side, he proposes for the GA1. So nothing remains in the matter. So I should get the orders. You should have been on this side. My lord, let us come to the facts of the case, my lord. May I just first, your lordship, my lord, your lordship will remember this is a section 92 suit. And my lord, there was an order passed by your lordship. And my lord, my learned friends have taken out an application. May I take your lordship through the application, my lord? Because then we would understand what is the scope of the application first. That's according to me the most important thing. My lord, kindly takes GA3 once, my lord.
GA3.
GA3.
Yes. Section 92.
Section 92. Well, the averments become a bit important because, well, two things. There is no revocation of, no application of Order 7, Rule 11. This is simplest revocation of leave under 42.
Sorry,
92,
section
sorry.
92.
92. Absolutely, well, what fell from your lordship, there is an intertwining of a point of clause 12 leave not having been taken. And that is one of his another point. But, my lord, the only thing in a section 92 proceeding I would have to show is that I'm interested in the trust. I seek for certain prayers which are provided under section 92. And even if there is some iota of charitable or public purpose, it will fall under section 92. I can ask for a leave under section 92 to invoke this provision. Now, well, it kindly takes the, but well, I must also point out, while the test remains the same, my learned friends cannot travel beyond the scope of the scope of the plaint and try and make out a case to show that no, this is not a section 92 suit. That's what I mean to say. No, I'm grateful. Now, Malad kindly sees his case. Malad kindly takes the application GA3. Malad, he starts from paragraph 3, Malad, page 4. Suit ex facie does not and cannot come within the four corners of section 92. Then, Malad, he narrates what is section 92.
Yes.
Then Malad kindly sees 5 saying that it's a private trust governed under the Indian Trust Act. The instrument said has been created according to the plaintiff, the deed of trust and explained is for the sake of convenience, copy is annexed. As would appear from the deed of trust of 12 January, same does not contain any clause from which it would appear the said trust was created for public purpose or any charitable or religious in nature. Now, I'll come to the definition of charitable. What would mean? What is charitable? Where does the word come from? So I will try and assist your lordship with the words also, Malad. But Malad, one thing, Malad will kindly see he admits. Malad, may I just take your first takes para 7, then I'll take your lordship to the other part of the. He says the plaintiff number 1 is one of the signatory to the addendum. That's what I've said. And then says, next page, page 6, Malad. Just in the middle of that paragraph, containing paragraph 7, Malad. The plaintiff numbers 1 and 2 ipso facto. Has Malad got that, Malad?
Yes,
page 6, Malad. The plaintiff numbers 1 and 2 ipso facto by announcing themselves as settlers could not have and cannot assume the character of the settlers of the said trust. Since the own showing the suit trust was created in 1942, a particular trust cannot be created by more than 2 documents as pleaded by the plaintiffs in the plaint. The only trust created in the name of Jugal Kishore was in 19 was a private trust, still is functioning, considering the construction of the later document of 3rd February 2022. The same is a deed of appointment of new trustees. No addendum and no addition. Now, what he says here, Malad will kindly appreciate that there is a second document. It can be maximum treated to be a deed of appointment of new trustees. He does not deny that I am a signatory to that. Malad, with this, I say that I fall under the provisions of section 92, where it says any interest in the trust. So whether I am a trustee, I am not a trustee.
It is not the case of the defendant that you are not a trustee and you cannot maintain.
So that's why,
Their case is
sorry.
that the criteria, whether you fulfill the criteria to obtain leave under section 19 of the CPC.
Absolutely, my lord.
The first is that it is a private trust, it is not a public trust.
Absolutely.
First thing. Second thing, what are the pleadings we have made in the plaint that is not covered under the clause of under section 92. And with regard to, there is nothing on record to so that the scheme is to be framed for in terms of section 92. These are the.
So that is what he says, but no, my lord, I'm saying because section 92, one of the condition is I have to have interest.
So that's why they have not denied.
So that is something,
not
no,
a
my lord,
trustee,
that is,
you cannot maintain. That is not the case they have made.
no, my lord, in para 7, they sought to, that's why I just pointed out, my lord,
Okay,
because
okay.
I'm going by the pleadings, my lord.
Okay.
Then, my lord, kindly sees, কি করবো গরিব মানুষ paragraph 8 my lord disturb kar na my lord, why I say so, my lord, kindly comes to page 7. The first thing is the plaintiff number 1 does not or cannot have an interest in the suit. Okay. That is why I made this submission, my lord. Okay. I am going by the pleadings because Mr. Ghosh has made certain submissions which are not there in the pleading. So my lord, that is why I am also trying to look at the pleadings, my lord. And cannot have an interest in suit trust or become a person having an interest in a suitor capable of applying for leave under clause section 92. Then my lord kindly sees paragraph 9. Claims to be the son of the plaintiff number 1, baldly recited, is the son and is related to the family of late Jugar Kishore Sujarmal Ruia as a person having an interest in the trust. An interest in the administration of trust, being a beneficiary therein. There is no pleadings or disclosure whatsoever of how the plaintiff has an interest in the trust. The administration of how he is a beneficiary of the trust. Well, once my learned friends accept that I belong to that family of Jugal Kishore Surajmal Rui Amalat, that itself provides that I will be a beneficiary. So again, the attack on the plaintiff number 1 and 2 as not having interest, well, that on the face of it, it is evident that it cannot be said so. Now my kind comes. The pleadings.
That's what I'm telling, but he is taking the precaution of the.
Milord, I will have little that I have, Milord, he also know. Well, whatever I can only argue, Milord, which I can substantiate in law and fact. I have not argued that.
I want to say that he is also
argue over than about the pleading.
That you can say, but
that is why I want to go through the pleading.
Okay, no problem. Continue.
I am showing as on my own volition that section 92, I am interested person. Admitting, that's very
That's
good.
I'm telling you.
That's very good. No, if he admits, that's a different.
He has not made any submission with regard to the plaintiffs and no locus to file. This is not.
It was there. That's why I took the point, Malad. Now he says if he admits, I don't have a problem, Malad. 10, Malad. Plaintiffs have made material misrepresentation in alleging to be persons capable of instituting the instant suit under section 92 of the code and seeking ex parte leave to institute the said suit. Leave under could not have been granted, that too in ex parte. In any event, such leave could not have been granted in favor or at the behest for the specific grounds taken herein above. So the grounds which have been taken herein above is that I do not have any interest. One, and second is it may not be charitable or public in nature. Now, para 12. Leave, if any, well, kindly sees, this is very important. Leave, if any, granted under section 92 of the Code of Civil Procedure, institution of this instant suit is thus liable to be revoked and the instituted suit is liable to be dismissed. This is more so since no leave under clause 12 of the latest patent of this honorable court has been sought or obtained, and by unduly applying under section 92 of the Code of Civil Procedure, the plaintiff has illegally bypassed clause 12. So he also appreciates that once section 92 leave is taken, then no further leave under clause 12 is required. That is why he's saying it's been bypassed. I'll be supporting with judgments also, but he did say that the properties of the suit or the trust are outside, therefore no leave has been taken, therefore the suit should be dismissed. Now, first of all, Malad, that is not his pleading. His pleading is that section 92 has been illegally taken, and that is why you have not taken a clause 12 leave. That is his pleading. Now, 13. It is therefore necessary in the interest of justice an order be made revoking the leave under section 92 of the court should be and in this to institute the present suit and dismiss the suit with cost. Then, my lord, ad interim order should be vacated. Thereafter, my lord, not the next 16 is very important, my lord. Fraud has been played by the plaintiffs in this honorable court. The institution of the instant suit and leave to institute the same has both been obtained by fraud. Fraud vitiates everything and unravels everything. Since the fraud has been played by the plaintiffs, particularly has been specifically pleaded, apparent that all benefits such one, including the ex parte order, should be vacated, immediately suspended. Plaintiffs have approached to extort money, undue benefit from the sent. That is therefore grave urgency in the matter, wanting an immediate order of stay and balance and whatever. This is his application. So, Malad, the only point which I humbly submit is fraud, Malad, question of fact. So, if he has to prove, he has to go to the suit, and whatever he has to get from there, he will get it from there. There is no application in the Order 7 Rule 11, so there is a disclosure of cause of action 7x to the extent he is saying it is not charitable in nature. That is what he says. Interest, he says that I have interest. No dispute about that. So now your lordship will kindly see the prayer is only limited to revoking the leave under section 92. That's it. So no dismissal of suit on the ground of not taking leave under clause 12 of the latest patent, or on the ground there is a suit for land. So these 2 points, my lord, I humbly submit is not a ground which has been contemplated in the pleadings. That is why I went through the pleadings, my lord. I'm trying to, my lord, move aside certain points which have been taken on the grounds of pleading. Now, my lord, kindly sees.
Yes.
The deed. My lord has read it several times. I'm sure, my lord. The deed, as a matter of fact, is, my lord, if your lordship is looking at GA3, my lord, it is starting from
37.
37, my lord. Now, my lord will kindly see. Now, my lord will kindly straight away comes to, my lord, paragraph 9, my lord. I'm not wrong.
9 of
Yes,
the deed.
9. We will start from page 42, my lord. That's typed copy, my lord. The subject to the provisions hereinafter contained, my lord, I'm just reading it, my lord.
Yes, yes.
As and when the aforesaid debts and liabilities of the estate shall be satisfied, the trustee shall spend the monies in their hand in the manner following: in payment of rates and taxes, government revenue, HON'BLE rent, other outgoings in respect to the trust properties, the same shall fall. Due in payment of the costs of necessary repairs to the trust properties, payment of the establishment charges, Calcutta and Joshiji, salary of clerk, releasing rents. And my lord, next page kindly sees. Rents of Joshiji property and supervised distribution almost in the observe of the trustee and a servant to cleanse the Dharmashala. Now, this is the point, Mala. It was meant.
May I have a lordship seal also continue?
A servant to cleanse the Dharmashala, assets in distribution and arms. So, Mala will kindly see assets in distribution of arms and for performance of all menial household duties on a pay of rent, exceeding such and such, wages of sweeper. So, my lord, arms are also to be given out. Alms means, my lord, I'll point out the dictionary meaning, my lord. It is gratuities given out to poor people. Alms. For for performance of menial houses, hold duties on a pay of rent, wages of a sweeper, a jashidi, wages of 2 malls. Then kindly sees 4, cost of lighting the harmonium. Fourthly, the trustee shall stand at least rupees 80 per month for sabadrata, daily food to the poor free. Well, it has got that.
Yes, yes.
At the said dharmashala. So there is a dharmashala. Dharmashalas are also religious properties meant for religious functions. Whatever it is, there is food being given out to the poor free in the nature of a public.
But Dharmasala is outside.
I don't understand.
Dharmasala is outside.
Jurisdiction. But I'll come to that later, I'm on the nature of the trust now. I'm on the nature of the trust.
Okay. Continue.
Well, the outside thing is a completely different thing. I'll come to that later, But since it fell from your lordship, I'll just point out this much, If I get leave under section 92, clause 12 leave is not required. And leave under section 92 says about subject matter of the trust, where the main trust office is within. And my prayer is, for a scheme. So partly or entirely, that is the section 92, talks about that. So this becomes the principal jurisdictional court. And if it is part, that is section 92 leave. So therefore, I'll come to that. Because since it fell from your lordship, I just wanted to point it out. But I'm not showing this for the purpose of showing jurisdiction, I'm trying to show, that this is with regard to the the public in nature. A minuscule part, I'm just for the purpose of this deed. Even if a minuscule part, it will be public in nature. One is that. Then will see setting up a patshala. Just after dharmashala, Fifthly, at C. Open at the garden house at Nashika in Ashighat at Banaras Patshala. To be styled Jugal Kishore Surajmal Ruiya Patshala. Where the said Jugal Kishore Ruiya Patshala used to be carried on, and that balance, if any of the income of the meeting, the expense as him, before provided spend a sum not exceeding of.
Patshala is there.
Yes.
Patshala is there.
Yes.
Still.
Yes. It's at Banaras, Ashighat. If I had known about this one, I went.
Ashighat.
I would have
Ashighat is having so many things.
Yes, Yes, it's a very. Huh? Yes, now, in his reply, I'm grateful to my learned friend, Mr. Shastri. He has said, where it was said, Jugal Kishore Surajmal Ruiya Patshala, in brackets, they have written private school of Ruiya family. So, if that is what they are trying to say today, then they'll have to come up and give evidence for that. It's a patshala rendering education. The dharmashala is also providing for food for the poor. The trustees are required to give out alms in distribution. And what has the trustees or what has the petitioners before your lordship come and ask from your lordship? The only pleading is that let the trust carry on its purpose. And for that purpose, specific prayer of a scheme has been sought for. Whatever judgments my learned friends have shown, I will show that the Supreme Court, where it has struck down the leave, has done it where a personal gratification was being sought for by way of the relief.
Correct.
Here I don't have any personal gratification. I am saying scheme or don't let them do it. I am not asking I will have to do it. Someone else does it. But I am showing that these people are not doing it for the purpose of the trust. The point is that certain aspects of this trust deed, my lord, it's a trust which was formed, my lord. Your lordship will also see in the pleadings, my lord, that it was made from a decree of this court. Now, my lord, certain part of the trust was providing for the benefits of the Ruya family. But part of it is also, my lord, the whatever proceeds were coming in were used for the public in nature, public at large, which includes, my lord, education imparting, my lord, patshala, dharmshala, giving out of alms, and feeding the poor. Now, my lord, your lordship will not find, my lord, the definition of charitable in, my lord, as far as I understand, my lord, in, my lord, the code, my lord. Your lordship will kindly allow me to just place once, my lord, section 92 first, and then I'll take your lordship the definition of charitable from the Charitable Endowments Act. Now, my lord, kindly takes section 92 once, my lord. First, my lord, this section, my lord, falls under the heading, my lord, public nuisances and other wrongful acts affecting the public. Just above section 91, your lordship will find. So any act which would affect the public or its rights are covered by these sections, my lord. Now, your lordship will kindly see section 92. In the case of any alleged breach of any express or constructive trust created for public purpose of a charitable or religious nature, or where the direction of the court is deemed necessary for the administration of any such trust. So, breach or administration. The Advocate General or two or more persons having an interest in the trust and having obtained the leave of the court may institute a suit, whether contentious or not, in the principal civil court of original jurisdiction, or in any other court empowered in that behalf by the state government within the local limits of whose jurisdiction the whole or any part of the subject matter of the trust is situated. So here I say, Malad, the main trust office, Malad, is in Calcutta within the jurisdiction. Now, your lordship, yes, trust also says so, and the plaint also says so. I'm on the plaint. Malad, kindly sees the plaint, Malad. Though, Malad, no case for order 7 to 11, but still I must show your lordship that, Malad. Because I am of the view that he should be restricted to his pleadings. But since it's a query from your lordship, Malad, I must deal with it. না আমার প্লেনটা আলাদা ছিল প্লেনটা কোথায় গেল মোটাটা বোধহয় প্লেন না
Yes.
GH3, okay. No, I had marked it, that's why. Yes, my lord. My lord, kindly sees, my lord. 28. Para 1, my lord. Third line. Office of the trust is situated at Jyotindra Mohan Avenue, PS Bortola, Kolkata 6, within the officer's jurisdiction. But on the basis of this amendment, it is good enough. Because this is not like clause 12. I will not have to write that this is within, this is outside. Subject matter part, any part. Then, my lord, in para 7, We have also said that there are certain properties within and certain outside.
Yes.
Then your lordship will kindly see there are 2 points which has been made out, my lord. Kindly sees 9, my lord. In order to ensure for effective administration. That 2022 was created, my lord. The second instrument. I never said it's a trust deed. I said it was a continuance. Then, my lord, the clauses have been pointed out from there, my lord. Then, my lord, 11. The plaintiff now had always ensured the objects of the trust is achieved to the fullest extent. Although the plaintiffs have not been administrating the affairs of the trust, it was only the defendants who were discharging such obligation, or the plaintiffs at all times were always made to believe by the defendants, and more particularly the defendant number 3 and 4, the functioning of the trust is being done in the terms of the object for which it has been constituted. Be that as it may, it now appears that defendants are now not acting in terms of the spirit of the trust deed and committing illegal acts is more fully stated hereinafter, so that the administration of the trust and its properties are being made by the defendants only to derive personal benefits contrary to the interest of the trust. So it is not a personal trust. The interest is for the public, and that is what we are trying to prevent here.
Yes.
The personal use of the trust properties. Then, my lord kindly sees paragraph 16 also echoes the same thing.
Yes.
Page 8, my lord. My lord, the last part of the sentence, my lord, that they are using the properties mentioned in the memorandum to the exclusion of the object of the trust for their own personal benefit. Again, 18 the same thing, and 19 specifies that it has taken over the control and the property, in spite of the same being charitable and religious, are using the trust properties for their own personal benefit. Why is it charitable and religious, my lord? It talks about a Shiva temple. I am not going into that because, my lord, that also speaks about, my lord, entry of persons authorized by the Ruya family. So it can be stated that it's for a private use. But for the charitable part, my lord, I can show, and I've shown, my lord, that it has been told by the trust or the settlers that these will be used for the patshala, dharmashala, payment of alms, and providing free food for the poor. So, my lord, this is what I have stated. What else will I state?
Okay.
Whatever the trust property will inure, or rather earn, will be used for the public purpose. Now, if this money, whichever they are trying to, according to us, they are trying to deal with it, well, if that money is siphoned away, one. Second, if that is not getting the highest price, but everything will effectively attach itself to the trust object not being achieved. That is why I'm before your lordship, and I'm asking for your lordship to frame a scheme. I'm not asking for anything else. What have I asked for, Mallet? May I just come to that straight on? But kindly takes, Mallet, para 26. I have mentioned the scheme be made. First, I've asked for decree for removal of the different number 3 and 4, and a scheme be made by this honorable court for the administration and management of the trust. And now, my lord, will kindly see the prayers, page 12 of the plaint, my lord.
Yeah, that I gone through.
Scheme declarations, my lord, kindly keeps note, my lord, that not a single prayer asking for any relief in my favor. Not a single prayer. One, and my lord, the suit for land part, my lord. First I said it cannot be because section 92. And my lord, what is a suit for land? But I'll have to show all those lines of judgment at concern where possession or title is being sought to be transferred. I'm not doing that. Where is the question of suit for land? That is what I wanted to submit, my lord, while I tried to show your lordship the scope of their application.
Yes.
Now, my lord, kindly takes. Again, my lord, I'll just show your lordship once more section 92, my lord. My lord, I have read 92.1. Whole or any part of the subject matter of the trust is situated to obtain a decree. Now, my lord, kindly sees G. 92.1G. This is what I'm asking for. And H is granting such further or other relief as the nature of the case may require. Now, my lord, if I'm asking for a settlement of a scheme, showing that my learned friends are not acting in terms of the, my lord, the trust deed, then what is the consequential relief I can claim?
That's regarding with regard to your prayer, there is no problem. You ask for the scheme.
Yes.
And you ask for the removal of the defendant number 2 and 3.
So that is consequential.
That is consequential.
Because,
because that's why for the allegation you wanted the scheme is to be framed so that your
why I'm continuously harping on this point, my lord, that I have not sought for any prayers in my favor, because most of the judgments your lordship will find what has been referred to has decided the leave to be revoked or not to be revoked on
personal
the point
interest.
of yes,
personal interest. That's right.
That in the garb you are asking for something for your personal relief. Here I have not asked for that.
Court has to see the both the side which
yes. And next, my lord, whether now at this stage, my lord, can your lordship, kindly does not take me amiss, my lord, can your lordship with certainty come to a conclusion that no, it does not function in any way as a public trust, or it is not providing any public service? That is the question at this point of time, my lord. The certainty will come later. My lord, your lordship also knows, my lord, in section now clause 12. Revocations also, the Supreme Court has said, push it back. At the trial of the suit, you'll see. Isha.
That's why. First, I put that question whether the 92 can be revoked at the summary stage or at the time.
Well, the test will be the same. If it is, my lord, like we do for limitation, my lord. Ex facie, definitely. If it's not ex facie, it will go.
Put the question to then. The first question put to Mr. Devnath, to Mr. Ghosh with regard to the whether this court can revoke on the summary procedure or as a preliminary.
Because one of the main judgment which he has shown, Malad, that is a preliminary issue. In that main judgment, Malad, that was Vidya Thora Trust, 2008 Supreme Court. There also the district judge framed a preliminary issue. Preliminary issue was that no, I will not revoke it. So that is why, Malad, that there the opportunity was given for that preliminary issue to be decided. Maybe evidence was also led. I am not sure about that. It doesn't say anything about that, but it can be led also at the preliminary stage.
No, that is the problem. See, every court says that there is a preliminary issue at the time of trial. If it is the preliminary issue at the time of trial, whether the trial is to be segregated for the preliminary issue or for the main issue.
Malad, I have, Malad, as a matter of fact, had the opportunity of arguing this at one point of time, Malad. There are a couple of judgments which say that you can lead evidence for the preliminary issue.
Correct.
And that is to be done separately. They do it separately only on the question of finding out whether it's a preliminary issue or not. But in today's world, I think it would would be not a very good use of time, if I may say so. Because if you take the take whatever it is at one shot, then you can decide at one shot only. The preliminary
already now,
and my lord, now with humility, I'm just interjecting your lordship. Now the Supreme Court also, my lord, because we also once in a while have to be arbitrators, my lord. The Supreme Court has now said you have to pass a judgment on every issue. So your lordship, in preliminary issue, you cannot, your lordship will not set aside the entire suit.
No, that's why.
Your lordship will have to hold that if it is not a preliminary issue, then we'll have to pass a decree in all the issues. So that is now becoming a bit faded, my lord, at this point of time. Now, my lord, kindly takes, my lord. Kindly has a look at the Charitable Endowments Act, my lord. Because, my lord, this would throw a bit of light to the meaning of charitable purpose.
Yes.
Malad has got the Charitable Endowments Act, Malad. The first would be the Charitable and Religious Trust Act. It's the next one, Malad, the Charitable Endowments Act.
Yes.
Just to show what the legislature generally holds as a meaning of charitable purpose. Section 2. In this act, charitable purpose includes, sorry, Malad. Malad, may I hand over my copy and I'll find it from there. You got that, man. I'm grateful. Charitable purpose includes relief of the poor, education, medical relief, and the advancement of any other object of general public utility. I'm not on that. The first two, Mallet, I have shown your lordship, I'm fulfilling. And it talks about as an inclusive definition to be interpreted widely. So at this prima facie stage, Mallet, we are at the threshold, Mallet, whether I have shown in my plaint that yes, I say that this is a charitable purpose and it is not fulfilling, that these persons are not fulfilling that purpose. Therefore, Malad will kindly frame a scheme.
Yes.
Malad, may I come back next day? It's already.
Charitable includes the education, medical,
yes.
relief.
So first two, and it's an inclusive definition.
Yes.
Amichilam.
Yes.
May I come back? I'll need half an hour time more because I'll have to distinguish his judgments on it, and that's about it. Because I'll also argue on my GA1. Because your lordship is taking up both of them together.
Injunction.
And my lord, may I just point?
What is the difference of NGA?
GA1 হবে না? I don't understand. I think both the matters are appealing.
Okay, I will hear, no problem.
Yes, your lordship is passing orders in that way, my lord.
Because we have not made our submission.
You after I make submissions, I will open my case. I will open my case.
If you wanted to argue the GA1,
Obviously.
no problem. Then you
Your
can give the
lordship
reply both.
Yes, that is how it was said. Your lordship is passing orders in that fashion. But only one thing, my lord, last day, my lord, the interim order extension has not been recorded, my lord. Kindly sees, my lord, I'll just point out. But kindly sees, my lord, on 11th February, your lordship had made it till 27th of February.
Our
And
application.
14th February, my lord, your lordship heard, and then fixed on 3rd March. So, my lord, those 2 days, my lord, is your lordship.
Another application. Another application.
If your lordship says.
You're objecting? Interim order?
Lord, they have got it. Of course, my lord, my clients object to it.
But suffering for the, come with an application. Come with
2 days, my lord, Saturday, Sunday. 2 days are Monday.
Son suffering for the plaintiff, son suffering for the plaintiff has argued the matter at length in connection with GA 3 of 2022, but due to paucity of time, hearing could not be completed. Let this matter appear. Give the date. कब है? 17th March at 3:45 p.m.
सबाई लाल है आज में and they'll be all colorful by that time, my lord. Just after Holi.
16 it is over.
That's why I'm saying they'll all turn out colorful, my lord. But kindly extend the interim order, my lord.
Counsel for the plaintiff submit that initially the interim order was granted and by an order dated 11th February 2025, this court has extended the interim order till 27th of February 2025 or until further order, whichever is earlier. But the matter speaks today, and due to inadvertence, learned counsel for the plaintiff could not mention the matter for extension of the interim order. And as such, he prays for reimposition of the interim order, which expired on 28th of February 2025. 8th of February 2025. So, learned counsel for the defendant raised objection and submitted that the plaintiff has not made any prayer for extension of the interim order on 27th of February 2025. And the plaintiff has also not filed any application for reimposition of the interim order. And as such, the interim order cannot be reimposed. Consider the submission made by the counsel for the respective parties. This court find that the plaintiff is enjoying the interim order, which was extended till 27th of February 2025. But on 27th, the learned counsel for the plaintiff could not mention the matter for extension of the interim order. This court of the view, none of the party will be prejudiced if the interim order is reimposed till the hearing of the reimposed and full stop. Accordingly, the interim order, which has expired on 28th of May February 2025, is extended till kab diya date? 17.
Malad, could it be the 18th, Malad, 17th? I've just inquired from your lordship's office, Malad. If your lordship feels that way, Malad.
Till 20 March 2025 or until further order, whichever is earlier. जो 17 है उसके 18 कर.
I'm very grateful, Malad. Very grateful.
Malad, the interim order is
earlier given ना 17 का.
हाँ,
उसको 18 कर दीजिए.
With Milord's kind leave, may I please mention a matter, Milord, seeking an extension of the interim order, Milord. Milord,
Interim order?
Milord, it is extended till 4th of March, Milords.
So today we are on 3rd, sir. Come
so much Calcutta.
Today we are on 3rd.
So, Milords,
Come tomorrow.
Milord, it's not running in the list, Milords. And tomorrow we'll
extension में उसमें रख दो, mentioning में रख. Yes, anything?
But item number 21, extension of interim order expiring today.
So appearing for the plaintiff, none appears on behalf of the defendant. Counsel for the plaintiff has mentioned, though the matter is listed listed item number 21, but matter could not be taken up for hearing due to paucity of time. Accordingly, counsel for the plaintiff prays for extension of the interim order. Considering the submission made by the counsel for the plaintiff, the interim order, which is going to be expired today, is extended till 28th of March 2025 or until further order, whichever is earlier.